Yes. Hmm. Item number 20 to be listed after the Puja vacations. Hmm. There was a direction passed by this court to file affidavit. No, there was a direction to pass by affidavit.
By 11. By 11, it was. This driver was not there.
3,350.
These are two methods.
So make it 3,000, 6,750.
I live by Tuesday or Monday.
No, the cost if it is not given, otherwise the order becomes meaningless.
These matters are usually handled by another council. So we have that opportunity to.
When last time your counsel only appeared,
They see
he appeared. Then both of you are now different. Then
the department was also not got the knowledge of this. Extra we sent an overnight manner they done prepared, and I was also not just Monday or Tuesday. It's not possible.
Mr. D. Gogoi, the learned counsel appearing on behalf of the Excise Department, seeks for an accommodation. For filing the affidavit on behalf of the Excise Department. This court had on earlier, he further submits that the said affidavit would be filed by Tuesday. By 17th of October 2023 without fail. Taking into account the above, this court adjourns the matter to be listed again. When is that same type of matters?
Lordship, there is a little difference there because they are contesting the finding of the joint committee.
Be listed again on. When did I fix the other matters?
Lordship, after Puja.
That I know, but I gave a date because there is an interim
I'm
order.
not wrong, 9th November or 11th.
Be listed. It can't be. It's on a Saturday. You want to come on Saturday? Then be listed again on 14th of November 2023. Not that. On 15th of November 2023. The interim order passed earlier shall continue till then. It is made clear that if the affidavit is not filed by 17/10/2023, the Excise Department shall have the liberty to file the affidavit on or before the next day, provided they deposit the cost of rupees 3,350. (32 and 33). Very well, okay? Down. A. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that the writ petition has become infructuous and as such would not like to press the writ petition. Taking into account the above, the writ petition stands closed on withdrawal. Interim order, if any, stands vacated. 5. You are appearing for which department? SC Corporation Department. Yes, tell me. Your main counsel, the petitioner counsel, happens to be the standing counsel of SC Corporation. Mr. S.K. Talukdar. Your senior is G. Bordloi. Okay. Why do you want an adjournment? Why? 2017 matter, 6 years have passed by. Then, what, have you taken the consent of the other side? Yeah, let us hear the other side, then only I will accommodate. Let's see. Next. Hmm. What is the matter about?
Regarding the arm license, I have applied for arm license for lordship. I've again applied for arm license in the meantime, by another file number, your lordship. That has to be put into record,
Mr. Iverson, appearing on behalf of the petitioner, submits that there has been certain developments in the matter pursuant to the filing of the writ petition, for which he wants to file an additional affidavit. So, taking into account the above, let the matter be listed after 6 weeks. In the meantime, the affidavit may be filed. Your name? Mr. M.K. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that he has received instructions to withdraw the instant writ petition. Taking into account the above, the writ petition stands closed on withdrawal. And first, the interim order, if any, stands vacated. What is this 2019 motion? Why? You have been asking for time.
In cooperative society of the photo number 679 are not controlling the execution of their mortgage. So
Should not be surgery to cancel, should not be issued by cancellation of the registration of so and so, so and so, and so and so. And so and so issued by the Assistant Register of Cooperative Society under Imam. Who are you?
but we are similar shareholders.
All the cooperative society.
Support SS Limited. Now, support SS Limited has been allowed by percentage in high cooperative society. Initially, those four societies are being shareholders of our society. Now, since board have been allowed by percentage, but they are not controlling. So we have filed a appeal before the register. Look into the matter and let necessary action. Since they are not controlling.
Then?
That case 26.
Then what happened?
Case 26.
They have not decided this.
Yes.
Who is appearing for the corporation department? No one. He's PNRD. Issue notice making it returnable by 11th of December 2023. None appears on behalf of the respondent number 1, 2, 3, 4, which is who are officials of the Corporation Department of the Government of Assam. Mr. M.U. Mondal, the learned counsel appearing on behalf of the petitioner, submits that there are standing councils of the Corporation Department appointed and he may be permitted to take steps upon the state respondents by way of serving copies upon the said standing councils. In that view of the matter, this court grants the liberty to the petitioner to take steps upon the respondent numbers 1 to 4 by serving extra copies of the writ petition upon any of the standing council of the corporation department. As regards the respondent number 5 to 9, the petitioner is directed to take steps by way of registered as well as usual within 7 days from today. List according.
Number 2, what was the everything?
Hmm. What is that interim order? Let us see.
The relevant portion matter. Last part matter. Until further order, the private respondent shall maintain the status quo with regard to the land allotted and shall not raise any construction and use the land for any purpose.
Hmm.
What had happened, madam, the case is that the Anchalik Panchayat of Pekamai has issued a notification for allotment of the land here at the Hatsumari Market. And the petition, the respondents, were now the applicants, they were, since long time, they were doing businesses in their market.
You were doing.
Yes.
Ah.
Then we have applied pursuant to that notification, madam. And accordingly, the Anchalik Panchayat has allotted us land. And this notification is at page 18. Madam.
Who are you?
Where the allotment order,
Allotment has been made for running a market.
not bad.
For what?
Because some land, some portion of the land of the market allotted to us for construction a shops for running our
Have been allotted.
allotted.
There.
Accordingly allotted, and we have already constructed the houses over the plot of land. In the meanwhile, the petitioner has to find the petitioner. He is neither participated in the allotment, nor he is interested in the allotment. Even he expressed that he has no grievance against the allotment. His only grievance is that regarding inconvenience, ingress and egress to his patta land. Due to the construction of the south over the allotted plot of land. Nothing is, even he has not challenged my allotment orders. And in fact, Mala, that is also not correct, but I have the photographs. So in that town, Mala, the requisition is not at all mandatory.
Oh.
He has such type of grievance, whether he ought to have been approached with the civil court.
Yes, Mr. Bani.
This is
What is your prayer? Let us see.
Yes.
To forfeit, dispose of the representations dated so and so and after holding a detailed inquiry into the matter in terms of the materials on record and as pleaded above, and accordingly issue direction to the authority to dismantle the structures constructed over the land allotted for bus stand. Bus stand?
Well, he stated that bus stand,
Oh,
but in fact, the land is not for bus stand.
where is the allotment?
But an allotment order is that in my IA, whether
Hmm.
the page 26,
Eh?
page 20,
Yeah, the allotment letter.
allotment letter.
And so is hereby allotted for you for doing business
Yes.
under the following terms mentioned above. Then
Then I have
to
constructed the
private,
house.
place the private respondents. Will be at the correct corner. Yes. The entire thing is that the land, the allotment is for busting.
The jurisdictional authority have approved this parcel of land infrastructure. We are happy with it.
No, we are not concerned. Here there is an allotment which has been made to them of as regards for doing business. Who are you?
What you say?
Without challenging the allotment letter.
We are not even challenging that. What you are saying,
Absolutely, without challenging the allotment, how can you do that?
the document take place 90 of the requisition
Hmm,
or 80 of the requisition.
hmm. Yes.
This is the allotment order issue.
Hmm.
There is no schedule, no date, undated. This has been issued.
Which one?
The authority petition.
Page 18.
18.
Let us read it.
19, primary, the assemblies purpose.
Read it.
Page 19.
Page 18, 17,
English one,
page 17.
page 17. Same.
Okay. Page 19.
Page 17, primary.
Okay.
Practically answer of content of almost. Along with the সাপ্তাহিক পূজা, দৈনিক পূজা, ব্যবহার কৰিব পাৰে।
ব্যৱহাৰ কৰিব বাবে।
ব্যবহার কৰিব বাবে নিম্নত তপসী তিনিটা সেটি এটা পূজ্য প্রশ্ন আছে।
হ্যাঁ?
যদি দেখে একেবারে আঞ্চলিক পর্যায়ে অধীনস্থ কর্মকর্তা প্রাকৃতিক পর্যায়ে দৈনিক পর্যায়ে হাটচিনিবাড়ি সুপার মার্কেটত আপনার ব্যবহার করবার বাবে নিম্নত তপসী আর শর্ত হবে নিম্নত তপসীতে শিডিউল দিয়েছে। কিন্তু শিডিউল
The Mati Kali, 14 feet by 1 square feet.
14 by 15 by 200 feet.
Then,
Borgo, that's square foot. I give approximation of the square foot without a schedule. You settle upon a land which is approved for the past 10, I represent the responding authorities. It's just 7 block and this honorable for the past and order in the of the application law. 30/18, ADIA. The honorable court had passed an order. Noticing this conflict.
no. Here, you kindly come to page 26 of its I.
Of the I. Yes. I think my 21, big petition.
Yes.
This 26 and 27 will be there.
Yes.
These dates are conspicuously missing in the original one.
Sapon Sutradhar.
There we go. I'm not on the dates again. This proposal and dates were.
No. Yeah, you see, your document and his document is different.
Page 21.
No, kindly come page 21 and page 27. See the difference.
My lord is page number.
IA page 27 and your page 21.
And
Your page 21 and his IL page.
21.
Yes. See the difference?
Difference is schedule and dates are inserted.
Yes, that.
I am still not on that. 30/11/2018 is the notice. I just on the book for by the beginning I and there's a order passed by the honorable court. Now read that order. 30th of November 2018. Passed the IA.
In the IA,
The IA. In the IA, it was passed.
13th of
30. November 30th.
yes, tell me.
The last part of it, the first page. Family. Under the circumstances and in order to appreciate the facts in the correct perspective, this court is invited to direct the petitioner as well as the applicant's area to produce at least 2 photos showing the site of the allotted shop vis-a-vis the right of ingress and egress claimed by the petitioner. Taking note of the fact that as per minutes of the SDLAC of South Samara, Mankacha subdivision, Hatsingmari, developed 21/97 by Demonstration. There Hatsingmari shows SDLAC committee to resolution and similar amendment have approved as follows, as if for a moment. Therefore, the present land advisory committee of South Salmara Mankacha district shall inspect the area and inform. the
Are you saying that the bus stand has been on the basis of a land advisory committee?
Approval of the front of the bus stand.
No, whether there has been an allotment order for the bus stand?
The crack says.
No. That court has done, that is different. This court is not. First of all, without challenging here, you have no business. Matter over. Nothing doing. No, Mr. Manik, enough is enough. They have been allotted. Without challenging the allotment, you can't maintain this reputation.
Then I think to withdraw with the liberty level.
Yeah.
Anything tomorrow or day after tomorrow.
What?
Then instruction may fall.
For what? I'm not asking you to withdraw. I'm not giving you the liberty. You want to withdraw. It's a different thing. But the question is, otherwise I am dismissing it.
I can see what your logic is going. The difficulty is which we forecast is now. They have constructed the land lot that the rightfully maybe pointed out, challenge the allotment orders and then come to expressive remarks. But the representation that pending before the authorities.
I'm not concerned with the representations out there. If those are representations out there, you have an ingress in egress problem, that is your private house. It's your private land. And if you have an egress problem, that is a case of a civil court. Right, your right to easement, which is the question out here. Huh?
Would it be on Monday to be safer?
Why?
18 ballot of-
For what? For withdrawal?
For an instruction, I think.
Instruction 2 o'clock at best. Nothing doing. Enough is my goodness, this type of cases.
But also consider that the direction from this court for the report.
Not necessary. That was that court.
It-
Unluckily.
it another outcome, but it has clearly indicated.
Not necessary.
But the report is not portrait. The photographs and detail of the report.
Let it be. Why- No, you see, unless you challenge the set, because your entire edifice of your case is that it is a Boston allotment. As of now, there is no allotment for Boston. So if there is no allotment for Boston, there's nothing. Merely making by the subdivisional land advisory committee that a recommendation, that recommendation has no value. Even that day I have held, even the governor saying that I recommend that this person should get it. Cannot be a right, cannot be conferred unless there is an order to the effect. A settlement is given.
Anyways,
Two. And if you withdraw, the bonus is on account of puja, is that I may direct the authorities concerned that to look into the representation. That is the only thing I can do. Otherwise, there's nothing. And that is on account of puja. Okay, next.
Okay, what are you? What are you doing?
Whom do you want to implead? Huh? Boroland, oh, Boroland Welfare Department. Oh, that problem. The instant application has been filed by the petitioner to implead the Boroland Welfare Department of the government of Assam as a party to the instant dispute, taking into account that the earlier department, that is the welfare and plain tribes and backward classes department, have already been trifurcated. That is what I'm saying, trifurcated into 3 departments. And the issue involved pertains to the department, pertains to the Boroland Welfare Department. Taking into account the above, this court deems it proper that the Boroland Welfare Department of the government of Assam, represented by the Secretary to the government of Assam, is required to be made a party to the instant, to the accompanying petition. Accordingly, the Boroland Welfare Department, government of Assam, represented by the Secretary, having his office at Dispur, Principal Secretary, na? The principal, represented by the Principal Secretary, having his office at Dispur, Guwahati 781006, is impleaded as the respondent number 5 to the accompanying petition. The petitioner is directed to file an amended cause title before the registry of this court forthwith, and the registry, on the basis of the instant order as well as the amended cause title, shall make necessary changes to the accompanying petition and also update the same in the CIS. I stands disposed. He cannot do, mean cannot do. You are appearing.
Was already by not.
Firstly, main petition of them. Taking into account the order passed in I number so and so, whereby the newly impleaded respondent, and whereby our respondent have been impleaded, whereby the respondent number 5 has been impleaded to the instant petition. Mr. Ardhor, the learned additional senior government advocate, accepts notice on behalf of the respondent number 5. Whose extra copy of the petition be served upon him during the course of the day. Mr. Ardhor submits that he would like to file an affidavit that the department would like to file an affidavit in the matter. Accordingly, list the matter again on 6th of December 2023. The affidavit be filed by 28th of November.
They want.
I know.
By the time, by probability matter, I have.
Earlier you have, but without authority.
So now, my lord.
No, earlier you had, but without authority. That is why I asked him to make them.
Now, my lord. With the power of the executive will be my lord. Now, it is for the education department, able to my lord. In the view, what will notify. So I think yes, by the time my lord, yes, comes.
So it will become a- Because once a notice is being issued, then only they will take the steps. And when they put a warning for filing the affidavit on a particular date, then only things move. None appears on behalf of the petitioner on cause. It is also seen that the petitioner is not represented on 2 other occasions earlier. So it seems that the petitioner had lost interest in the petition, for which the instant petition stands dismissed for non-prosecution. Yes, manager, what is this case about?
But they are challenged the election in their own kind of.
1/8/2017.
Yes,
What is that order? Let's see.
873, my lord.
1/8/2017. Let us see. Removal of the term bank. Bureau of Investigation. With reference to the above, I am directed to inform you that the Honorable High Court had so and so had passed an order to take appropriate steps to remove the term bank from your nomenclature, if it still exists. It has been learned in the round 6 meeting of the state level coordination on the regulation of so and so, that you are using the term bank despite the fact that RBI has cancelled your banking license way back in 2005. In this regard, the respondent cooperative society have also initiated an inquiry into the matter of the order. Therefore, you are here. What is wrong with the order? No. What is the order passed by in the PIL? Let us see that. Where is the order passed in the PIL? And is your license operating? What do you want to do bank and where? Register is to make inquiry. We find from the inquiry report of the Joint Secretary that he is unable to secure the records from 13 closed branches and so on. We direct the respondent register to make the inquiry into the functioning of the cooperative entity. So the allegation made in this case can be. Where is the direction out here for removing the bank by the division bench? No, this is the order passed by the division bench. Where is that? No license can be expected for new urban cooperative banks or so and so. But you are no longer a bank, and why do you need the bank?
No, my lord. That's a right. The bank is, my lord, if name is bank, it is not in banking business. As what it is on the banking education and kind of. We are a chief society. Man.
Who are you? The petitioner?
I am for the respondent, my lord. Newly included. I was the affected party. I was not made a party. So I had to file an affidavit petition.
You are appearing for whom?
File an affidavit, my lord.
Huh?
My name is also not shown there.
Understood. Without the name also you are appearing. That means you know it very well. Anyways, you are the Union Cooperative Bank.
Yes, ma'am.
Now-
It's actually a street society under the Cooperative Societies Act, my lord. We are doing business, we are allowed to do business and we are doing business within.
And who has filed this petition?
We are taking
Managers, what business you have?
Well, they are branches, madam, managers, they have formed some association, madam, they are. But without making other partners, we don't, we need to file an application.
Understood, but he may be aggrieved,
I am affected.
but he has not filed the writ petition. You have filed the writ petition. Who are you to say that?
We are facing lots of problems because we are the manager for this culture.
No, whether, no, only, Mr. Council, only show me one thing. This order of 1/8/2017 is on the basis of the order passed by the division bench. Okay. In the division bench, whether there is a direction to remove the word bank. I am directed to inform you that the Honorable Court so and so had passed an order to take appropriate steps to remove the term bank from your nomenclature if it exists. If that term that is given out there, how can this court under a single bench decide this? Page? And who is paying for this? Bureau of Investigation. Or none appears for the Bureau of Investigation. Page 51. 20. We find from the inquiry report of that he was unable to secure the records of it. Moreover, even the impression on answers did not cooperate with the inquiry, but it is important to protect the interest. So both groups are given the liberty to apply before the register for its effective intervention. In our perception, a competent authority to confer is likely to allow
This inquiry was directed, that inquiry is not a.
No, where is the order of removing the term bank? No. As per the division bench. Page?
The order in principle approval was
Page 20,
done by the RBI.
page 20,
27.
27. Ah,
With the order by the RBI, withdrawing the in principle approval to the bank.
in exercise of the above, it is concluded the proposed bank is not complying with so and so. Keeping in view these findings, the Reserve Bank is satisfied that continuing the activities of such entity of granting of license to such entity would be detrimental to the interest. And therefore, in exercise of the powers granted to the Reserve Bank of India under so and so, the in principle approval granted to the proposed union stands withdrawn from the date of receipt of this order. The proposed union shall therefore stop conducting banking business from the date of receipt of this order, and deposits collected by it from non-members should be refunded immediately.
We have complied with that. General people cannot.
After the order, they cannot take the
Vote is also called upon to create a use. Now, where is the direction that not to use the bank? Huh? Yes, BIEO. You are there. Your order has been put to challenge. And what is your business? They would? Questioning what? Who are you? That they will ask the cooperatives, that bank, not you. So managers, are you not employees? So if you are employees out there, what is there? We are not concerned with that, but you are employees. Tomorrow you may not remain. But why the bank terms should continue when they don't have a license? No, let them leave. But what is wrong with removing the word bank? And if the investors come, very well. You should also aid them.
the name, then what is it? There suddenly we don't know
Huh?
can be the case if people, if there is a application
Page
regarding the license, if people.
54. 54, application for license to the Union Cooperative Bank under the banking regulation from registered cooperative to the chief manager so and so. Then what happened?
Thereafter, what is managing authority had their time to apply for the license.
No. What is wrong? You don't have the license of bank now. So bank, there is nothing wrong. Tomorrow you have the license, it is okay. What do you say?
Yes, sir. So, otherwise,
And it is his baby you are carrying.
but
No.
yes, responsibility are from the.
The instant writ petition has been filed by the petitioner. Challenging the order dated 1/8/2017 issued by the Superintendent of Police, Bureau of Investigation, bracket EO, Assam, directing the Managing Director of the Union Cooperative Bank Limited to remove the term bank from the nomenclature. Full stop. This court finds it relevant to take note of that the said order has not been put to challenge by the Union Cooperative Bank Limited, who is the respondent number 5 in the petition. However, the challenge to the said order is being made by the Managers Association, of the Union Cooperative Bank Limited, as well as its General Secretary. Full stop. This court further finds it relevant to take note of that admittedly, the license which was issued to the respondent number 5 have been cancelled by the Reserve Bank of India by an order dated 8/9/2005. Full stop. It is also an admitted fact that pursuant to that, the said respondent number 5 is yet to be issued any license as required under the Banking Regulation Act of 1949. Full stop. This court have also perused the impugned order dated 1/8/2017, and a perusal thereof shows that this court, in its order dated 1/9/2016 in PIL number 33/2010, WPC number 2379/2014, and WPC number 4368/2016, 6, had passed order to take appropriate steps to remove the term bank from the nomenclature of the respondent number 5, if it still exists. Full stop. It also came to the notice of the Superintendent of Police of the Bureau of Investigation, EO Assam, that in the round 6 meeting of the state level coordination committee on regulation of activities of non-banking financial companies and unincorporated bodies held on 27/2017, the respondent number 5 was using the term bank despite the fact that the RBI had cancelled the banking license way back in the year 2005. Full stop. In that regard, the respondent, in that regard, the impugned communication was issued directing the managing director of the respondent number 5 not to use the term bank. Full stop. This court is in exercise, the exercise of the jurisdiction under Article 2 to 6 have been the petitioners herein have challenged the said order and have sought for a writ in the nature of certiorari for quashing of the impugned order dated 1/8/2017. This court, upon perusal of the said, it is a well-settled principle of law that a writ of certiorari cannot be, and that a party is not entitled for a writ of certiorari on a mere asking. This court further also takes note of that the respondent number 5 who is otherwise affected or who have been directed to remove the term bank from its name have also not challenged the impugned order dated 1/8/2017. Taking into account above, this court finds no reason to interfere with the impugned order dated 1/8/2017, for which the petition stands dismissed.
I have the affected party. And-
Huh?
But I don't know.
Why? No, so what? You had to file an affidavit. If you file an affidavit also, how does it make sense? You are the petitioner. You should have been the petitioner. You have not challenged. You are putting the gun. Are you trying to put the gun on his shoulder and fire it? This is what you are trying to do if you want. You are a respondent. This court, however, makes it clear that by the instant order, this court have not decided on the rights of the respondent number 5 to challenge the impugned order. The interim order, if any, stands vacant.
Number 6.
Huh? You got it? Mr. M.R. Kandakar, appearing on behalf of the petitioner, submits that the petitioner have already received the benefit for which the instant writ petition has been filed. Accordingly, the petitioner would not like to press the instant writ petition. In that view of the matter, the writ petition stands closed on withdrawal.
7.
Yes,
Non-payment of compensation for we have not received the extra copy till date.
then
2007 it was
what are you asking? Show me. To make fresh assessment of the compensation and pay the same to the petitioner in a time-bound manner as per the award dated 1/7. So the award has been passed. How can this court direct the respondent number 6? Tell me. Now, how is it possible this court can direct the respondent number 6? Under what provision this award has been passed? Page 37. Yes. Under what provision? whatever award of arbitration in the matter. So it is an arbitration award. It's an arbitration award. You are challenging in a writ.
No, we have not challenged you.
What are you asking?
Whatever the award has been given, we have to get the benefit as per the award.
So you have not got the benefit of the award.
That is,
No, why you are asking for a fresh, what is the award past?
that has been considered part of the award. itself.
In the case of Hailakandi, when the land valuation needs to be revised as per the so and so. In the case of the value of Jirat, which is based on 90, should be revised. So this is the award,
Award.
and pursuant to the award, they have not. Now, have you made the National Highway Authority a party? And who is appearing for the National Highway Authority? Huh? PWD NH division. Huh? So this acquisition has been done under the National Highway Act. Huh? Hmm. But you have not taken steps. No. Why you have not taken steps? In 2017 matter, you have not taken steps. You are not interested.
I don't know.
You may be having too many cases, so you can't track. Huh? Okay, we give you time for taking steps with a cost of 10,000 upon you. No, this can't happen like this. You take steps and then you pay. Let us see the office note, whether you have taken steps. Office note neither one. Yes, sweet. And how many petitioners? 4 petitioners. Then why only 60 rupees? Please not neither. In pass, sweet. Reason? No office notes. They file to her photo. What do you want? Cost? You missed out. That day, there were 2 matters, huh? Mr. UC Rabha. That matter, I got that, they got the money. They have already done all this. This is a similar matter where the DC rural was sitting over it from 2014 onwards on an award passed by the arbitrator, not doing it. And this is what has happened. But you are not interested. Not taking steps is not the mistake of the petitioner. It is of the lawyer. So the lawyer has to be penalized with 10,000 rupees fine. Then only things will move. And pay that money to Mr. Hendrik and him. What do you say with that? And the cost is to be given. Why legal? Legally, the central government is paying a lot of money. That means you are not interested. Okay, Mr. M.H. Laskar, huh? You have got receipt. So then we impose the cost upon Mr. Hendrik for making a wrong statement. C. Bulwa, kindly receive, acknowledge. C. Bulwa has received it. No, there is no steps, but what about the others? Mr. M. Pukon, Mr. C. Bulwa, then Mr. D. Nath. Where? Not there. This is of 2019, 2017, what have you have done? Mr. J. Hendek, appearing on behalf of the respondent, submits that that no instructions could be obtained in the matter, taking into account that the petitioner had not taken steps as pursuant to the issuance of notice on 16/11/2017. Mr. M.H. Laskar, the learned counsel for the petitioner, submits that he is going to serve extra copies upon each extra copies of the petition in respect of each of the respondents. Shall serve. You are paying for whom? For no PWD. No, PWD is not represented. You are for only 6.
I am already.
Shall serve extra copies of the writ petition to Mr. J. Hendek during the course of the day. You are okay with the copies? This court, however, finds it relevant to take note of that the counsels for the PWD are not present when the matter has been called. And you are appearing for 6 and this one also, na? You are not appearing. You are not there anywhere to be seen. What is your instruction? Tell me. Don't make you are not nowhere to be seen. When I make observe something, then only you will rush coming. You are appearing, Mr. Hendek, you are appearing for 6 and 7. Shall Mr. J. Hendek, you have extra copies of 2 extra copies to Mr. J. Hendek during the course of the day. Ms. S. Sharma appearing on behalf of the PWD. I can't help you. It is for the registry, or should I resort this, make this court a registry now? Appearing on behalf of the respondent number 4 and 5, submits that she will take instruction. Have you received copies? Submits that she has also not received copies, to which Mr. J. Hendek and Ms. S. Sharma, appearing on behalf of the respondents, numbers 4, 5, 6, and 7, submits that extra copies of the petition have not been served upon them pursuant to the order dated 16/11/2017. Mr. M.H. Laskar, the learned counsel for the petitioner, submits that he would supply 2 extra copies each to Ms. S. Sharma and Mr. J. Hendek during the course of the day. List the matter after in the month of February, some date. When can you get your instructions? Okay, list the matter again on 20/12/2023, on which date the respondents appearing on behalf of respondent number counsels representing the respondent numbers 4, 5, 6, and 7 shall apprise this court about their shall obtain the necessary instructions in there. What happened? Anything remains? No, if it is not registered, why you are not going there? Sakila Basu's judgment. What is this? That is why nothing has happened, and the court has issued notice and matter has gone. The instant writ petition has been filed by the petitioner. Is it in respect to the same offense? Huh? The instant petition has been filed by the petitioner, being agreed by the inaction on the part of the, which is Dergaon.
Yes.
Dergaon officer in charge of the Dergaon police station in registering the FIR. Filed on 27/8/2017. This, oh, no, it is the opinion of this, the law being well settled by the judgment of the Supreme Court in the case of Sakira Vasus versus so and so, it is done, reported in so and so. The remedy which is available to the petitioner is a remedy under section 156(3) of the Code of Criminal Procedure 1973. The petitioner, in that view of the matter, this court is not inclined to entertain the instant petition. Be that as it may, liberty is given to the petitioner to approach the appropriate court if so advised. If the petitioner still continues to be aggrieved.
My
Hmm.
That my lord, the schedule given is my lord wrong. Then it finds my lord, rectification date. And my lord, thereafter some.
What are these miscase? What miscase you have filed? For what? Yes. You have filed 2 miscases, not here. Your prayer is there are 2 miscases pending.
Rectification of the my lord, schedule.
Huh?
One schedule of the my lord.
What rectification?
Rectification of the particular land.
Huh?
What my lord is just it is wrongly, my lord. In the state it is wrongly executed, rectification did also. Hereafter also in the Sikha, my lord, they have not corrected the land.
Where are your applications?
Rectification, my lord,
What?
as to rectification, page 27.
Page 27. Page 27 is a rectification there. Where is your application?
Rectification, my lord, that, page 29.
You are, no, this is a notice. Where is your application? These are notices. No, you have to, if you want, no, you can take a certified copy, but how can this court decide what type of application I should direct? I don't know anything head or tail. Mrs. Ensaike, appearing on behalf of the petitioner, submits that she would like to file an affidavit bringing on record the applications which have been filed before the authorities by the petitioner. Miss.
At the time of.
No, but then why are you? Without that application, it becomes difficult. Huh? And who is appearing for the respondents? Ms. Yudas appearing on behalf of the circle officer. Where did you file it? Circle officer. Appearing on behalf of the respondents, number 2 and 3, shall also obtain instructions as to why the miss case number 645/2014-15 and miss case number KRC bracket M number 161/2015. Shall obtain the status as regards miss case number 645/2014-15 and miss case number KRC M number 161/2015 on the next day. List the matter again on, when do you want it? January, February,
Last week of the-
what? November? November, no more dates. It's flooded. We'll have it on a good date, 13th of December. Yes, what is this?
Instructions were not available, but what the instructions, the 2017 map, what has happened in this case, the petitioner has come with a prayer. First, the balance part of.
To release the outstanding loan amount and further direction may be issued to the respondent to allow the user to continue their loan account.
Yes.
That direction this court can't give. But for release of the outstanding loan amount, that you should consider.
In this case, that the concerned branch manager, logically, that in this case, the petitioners belong to Silchar. And the loan has been disbursed from the Nongpo branch in Meghalaya. But absolutely, without any power to disburse the loan, as many as 60+ accounts, that branch manager disbursed large number of loans. And these petitioners, the sanction letter disclosed that these petitioners have no business whatsoever. And that branch manager will be departmentally proceeded to impose the major penalty also. So these instructions I have. But I pray for short time maybe done.
You took the loan from Nongpu. Who is your senior? You want to file an affidavit?
And their loan accounts are already NPA since 2017.
NPA?
NPA.
Where?
Because
Any document to the effect?
I have taken the.
No, you have a document. Then I dismiss it right now. If it is an NPA, how can this court direct for payment of anything? How can this court direct then, once you are an NPA? Hello, Mr. A. Ganguly appearing on behalf of the PNB, on behalf of the respondent bank submits that the petitioners herein are residents of Silchar and has no business or any properties at Nongpo. However, the then branch manager of the Nongpo branch of the respondent bank had granted the loan, had disbursed part of the loan, part of the loan amount. It is under such circumstances, the respondent bank had also taken steps, the disciplinary action against the then branch manager, and major penalty have also been imposed upon him. He further submits that the petitioner have also become an NPA. The petitioners, both the petitioners, he further submits that both the petitioners have become non-performing assets, accounts have become non-NPA. And as such, the question of the granting the reliefs as sought for does not arise. This court finds it relevant that these aspects be brought on record by way of an affidavit. Accordingly, list the matter. We'll have it immediately after vacation, close this matter, these type of matters now. On 8th of November 2023, the affidavit be filed by 6th of November 2022.
Well,
It is seen from the records that the petitioner had expired, as have been reflected in the order dated 26/9/2022. Under such circumstances, this court cannot proceed with the instant writ petition at the behest of a dead person, died
Yes, yes.
at the behest of the dead person,
Yes.
and as such, the writ petition stands closed as debated. Be that as it may, the closing of the instant writ petition shall not preclude the rights of the legal representatives of the petitioner if they continue to be aggrieved by the actions of the respondents. Give you a name. আগত উপর লিখে দিবে, হ্যাঁ? SC committee, legal aid.
13.
Yes,
Department, I like to find the reason that
what is this matter so important
eviction matter.
that Mr. Gogoi has attempted to file an affidavit and has filed an affidavit, which is otherwise very difficult to get an affidavit from him? Yes,
I was told that this, they are challenging, they are basically, the challenge matter, the requisition process way back of 19.
challenge,
Requisition process, not requisition, where, eviction carried out to, clear out an equipment. Now they come and say that these villages, they were the original inhabitants and who had not put the notice when this forest was declared. Where back in 1961.
what forest? Reserve forest?
The forest.
How can they? That day, that judgment now, what was that? I gave one judgment now, forest.
Dashrath Yadav.
No, the other one, Ratneswar.
Dashrath Kolita.
Ha.
Yes.
There I have dealt with that you cannot do so in view of the forest regulations out there. And even, and what they want, they are still possessing.
We are in. I will take an order, whereby just one more of PI was registered, to clear out eviction, encroaches from that specific Kolkata area.
Then,
And in that case, steps have been taken and we have received contact also.
or not removing.
Certain issues have come up. People are moving the court. They say they are like landless people. They are not. They are genuine land owners. They are things like that. So in that case, I'll bring it out of you. The PI must give the direction to clear all the equipment.
Was the impugned notices without any date issued by respond number 5 and 6, not to disturb the directing. You are in reserve forest? Is it proposed or has already happened?
Happened by the 1959.
Well, what rights? No rights.
I will be allowed as a legal director.
For what? Affidavit filed in 2018. You plan to file the rejoinder affidavit in 2023. This. Where is that notification? Page. There's no page out there, nothing to the effect. You have not enclosed anything. Kindly don't keep on relying on other orders. Where is the notification? If you are saying it to be a, here there has to be a government notification.
There is one, but
There is nothing.
there is no annex file.
Then
It is there.
Mr. D. Gogoi, appearing on behalf of the Forest Department, submits that the forest where the petitioners are in occupation is a reserve forest. However, the records does not show that any notification as per the Assam Forest Regulation 1891 have been issued. Mr. D. Gogoi submits that he shall take appropriate steps to bring on record such notifications as regards the reservation of the forest, wherein the petitioners are in occupation. List the matter again on, you don't want to evict, I suppose, seriously.
We want to evict.
You want to evict seriously or not?
Yes, it is.
Then why you have not done the most important thing?
This.
List the matter again on 8th of January 2024. The petitioner in the meantime would be at liberty to file their replies.
24, 14, 14.
Right?
14.
Yes. Yes, Mr. Dubey, there is no one to oppose you. Why? Or you have nobody to whom you can oppose. Why?
I had wrongly made a party respondent.
That is why. Otherwise, they won't.
The prayer which has been sought would have been given by.
Correct the surname of the petitioner as Das in place of Ghosh in the current voters list in Assam and treat the as a scheduled caste. My goodness. Otherwise, affidavits, and they have to make this.
Election Commission of India party.
Huh?
That is, as regard Lok Sabha and Gulab.
What looks up? This is the voters list.
Yes.
So they have to make the election commission a party. Not only that, they have to also, they want it to be recognized as SC.
Yes.
So without making the social justice empowerment committee, they can't. No? So anyway, the petitioner, however, none appears on behalf of the petitioner on call. It is also seen that on this court have also perused the writ petition as well as the relief sought for. Taking into account the above the relief sought for. Relief. However, a perusal of the array of parties, a perusal of the respondents shown arrayed in the instant writ petition does not show that the Election Commission of India as well as the Department of Social Justice and Empowerment of the government of Assam have been made parties to the instant writ petition. Taking into account that the petitioner is not represented, this court adjourns the matter to be listed again on 29th of November 2023. It is made clear that if the petitioner is not represented, this court shall dispose of, shall pass appropriate directions, shall dismiss the writ petition for non-prosecution on the next date. No, we have a state, na? Social department is there, na? This WPT has become three. One is social justice and empowerment. What is that department? Social justice and empowerment. One is social justice, one is tribal affairs, and one is Boroland. These are the three which has become. I think it is social justice. All these OBC backward classes, all these things now are being taken over by the social justice department of the government.
But we will take, matters related to annotation and any. They may make the also, some little university, some of it is. So for these petitioners, what can I, that will be started. And I am also not.
Why are so many petitioners?
They also get a name of
39. Why?
their, as going to the apartment bureaucracy, where I found that the survey was not conducted so far as this additional track.
Then,
At that point of time, they came. They have filed an affidavit. Meanwhile, nobody has-
what do they say in the affidavit?
So, you can take it up immediately on the opening. Thank you. I have a-
No, award has been passed.
Also, so far as these petitioners are concerned, the land compensation was not paid.
No, here it has been mentioned that this compensation has been paid. Regarding the representation submitted by Sri Ganesh Kumar and Ajit Setia, it is stated that both the above persons have received their respective GRAT compensation. Stated that Ajit Setia, there is number of joint patadars who have not yet submitted proper documents to receive the compensation of land, and the matter is still pending for disbursement on the submission of proper documents. But Ganesh Kumar has already received the compensation. So then,
That's why you wrote to have paid instruction on reopening.
okay, but pay the court fee. Court fee? Huh? Then don't have a contact, you cannot get away with paying only 60 rupees.
Okay, Rossi.
Yes. Mr. S. Bhattakur, appearing on behalf of the petitioner, submits that pursuant to the affidavit in opposition which has been filed, he would like to take instructions in the matter. Be that as it may, this court finds it relevant to take note of that there are 39 writ petitions. And however, having distinct and separate causes of action. However, the court fee of only one writ petitioner has been paid. Mr. S. Bhattakur submits that he shall pay the deficit court fee on or before the next date. List the matter again on 22nd of November 2023. Yes.
Let's say the acquires the fine. There is a stay order operating matter.
Hmm.
Now, that my lord, there were 3 cases. Out of which my lord, CID case itself was my lord, they themselves say there is nothing. Then as far as the complaint which was filed before the my lord anti-corruption department, that was again transferred to Superintendent of Police, who thereafter transferred it to jurisdiction police station, and they have also submitted a finding. And only case which is pending is my lord, this one, regular inquiry. That is by anti-corruption.
Hmm.
My humble submission is my lord on the same, in respect of the same transaction. That cannot be successive affair, that's the law to that.
And who, Mr. Parasar, you are paying for?
He was also.
Actually, CD call for the financial consultant to the earlier CD were written in the year 2020 or whatever. Today morning I had come to know that CD is not presently available.
My humble submission would be,
Hmm.
and prejudice again, not on that.
Hmm.
The question is whether successive cases can be filed based on the same. cause. And especially my lord, two affairs have ended in my lord. Final.
In respect to the same aspect.
Yes. Same again. Vicky Anthony and all these cases, my lord, were on the Supreme Court has made of the law.
And however, the third investigation is allowed to be continued by this court.
No, no,
No,
state.
No, what has been given is
No question.
no coercive matter. As an interim, it is provided the investigation in this case may continue, but no coercive measures should be taken against the petitioner without the leave of the court.
Yes.
To render full air. And what is your stand? Or you have nobody? Who is paying for the PP? You are the PP. Because earlier the PP was representing some of the officials. So now the case is under response number 8,
Yes, my lord.
the Superintendent of Police Chief Minister's Vigilance Cell.
Yes, yes.
Huh? So others have already been done.
Yes.
Five, I suppose. Who is representing 5?
Now, 9 is the
Now, my lord, the case rests with the respondent number 9.
There is some affidavits being filed by somebody. Affidavit number 8. 8 has said that submitted a complaint petition dated that the chief minister against the petitioner and 2 others against misappropriation of government funds by preparation of 28 numbers of receipt for carrying out the works of further. It is alleged in the complaint that about 1.1. Now to remand the deponents of the accepted as per the approval of the new chief minister, remand and letter has been sent to the petition director including the complaint demanded.
The complaint which was filed before the CM Vigilance, that was for referred to CID. But
Hmm.
CID says there is no mention. Respondent number. They filed affidavit of.
And response number 6 has filed affidavit.
Yes.
And then response number 8 only says that it has been forwarded.
Ah.
And what else remains?
So Lord, kindly come to the affidavit of respondent number 6, my lord.
I've seen
Page
it.
number 10.
Hmm.
The conclusion part. Page number 10, current second, chapter 1. During inquiry, it is ascertained that allegations submitted by the complainant allegations submitted for the substantiated and the information highlighted in the complaint petition is not found in the complaint. Allegation is found as perpetrated at some
Who is the complainant?
complainant is my lord. Who one Abu Mustafa, my lord. Respondent number 12.
And who is he? Yes, what is your case? He must be knowing something. Kindly come here.
Honest counsel, out of this also, we are going to address the
So,
So, I have seen whether 2 complaints are there, madam, just only there is some mistake proposal of one only, that is only.
no, these have been closed. So, Mr. K. Chaudhary, which is that authority now who has to say anything?
Respondent number 9.
9.
is the only top layer which is paid.
9.
Anti-corruption, vigilance and anti-corruption.
And that is same with 5.
Yes, yes.
So,
Same with five.
but 5 and 9, and this is different, and 4 is different from 5.
Yes, different.
Then will-
4 and 6, my lord, perhaps they are same.
So here, the inquiry which is pending is regarding 5 and 9.
Five.
Okay. And who is representing 5 and 9?
I can do the 9 minutes.
Okay. You file your affidavit
Fine.
on the next occasion. Mr. K. Parasar appearing on behalf of the respondent numbers 5 and 9. Now, and again, the taking into account the issue involved in the instant writ petition and the inquiry presently pending is so far relates to the respondent number 5 and 9. This court directs the said respondents to file their affidavit in the matter by 15th of November 2023. List the matter again on 22nd of November 2023. The interim order passed earlier shall continue. I don't think I need to mention anything because it is already there. Interim order to Talipur.
17.
Yes.
Other concepts that we did.
Hmm.
Of the law, the legislature, the land law, the other. And this building was, I think, voting number, it was accessed by the number. And kept in holding number 300. That holding number remained up to 87. 70%, and the holding number 6 has been created. And thereafter, my father died in 2009. And after his death, I left it for limitation of mining. My application is next 11. And
Yes.
page 37.
Hmm.
By this application, I wanted to use my name in place of my father. Then when the plotting plan is accepted, then it was under the municipal code was administrative. Mark and order. I was given the certificate on 28/9. This is certificate.
That you are the owner of the holding.
Yes.
Then
Then my the lordship and kindly see the and it's 18 minutes. It is 51. That's really.
yes.
The column serial number 2 measures. The holding number 6 of ward number 2 has been occupied by Atmaram House. Atmaram House, Ramsuri. But the plot of land occupied by holding one RCC hearing tag number 1011 was in the name of Nagarman. Rangoon Samka, which has been transferred to Mr. Dharmadam Reddy by this series number 2897 of 1998. The official transfer is made by administrator's order dated 7/2009. I submitted several applications regarding my notation, but there was not. And on according to this assessment manager on 7
to 2009, these were transferred. That means the mutation was, my mutation was cancelled and his name was included.
No, was the land transferred?
Land was transferred, this is not the land, but it is according to municipal board, this is their, my building's land has been transferred, this is according to municipal.
No, kindly come to Annex 13. You are referring to this sale deed.
Yes, sir.
Now, this sale deed, there has been a sale in favor of the respondent number 4.
Just one of four,
By whom?
by Nagarman Sankar. My brother-in-law. So my brother-in-law allowed to construct it, but some vacant land is there, in eastern part. And.
No, these are questions of facts which can only be decided by a civil court.
But.
How can this
So,
court
so far
decide?
mutation is concerned, the existing mutation that cannot be, without getting, that cannot be cancelled. That has been done here, when no notice was served, nothing else. And it was completely kept in that, the building was constructed by my father. And that holding over, and it said that one, Sally is there, Sally was there. And Sally was transferred. So, how the buildings are holding the that can be sent to the municipal board, without hearing, no notice was served. I have annexed all the tax payment certificate since 1969. And it's a 1 year old, right?
Yes, who is appearing for Nalbari Municipal Board? Who has done this? Nalbari Municipal Board.
Not very.
And what about the service upon Nalbari Municipal?
Not municipal board has no.
Huh?
Municipal board has no declared.
Has the service been complete? Somebody has appeared. Learned counsel has appeared on behalf of respondent number 234. How can it be? 4 is the private respondent. So, Wakalatnama Khansa. Mr. Goswami, you are appearing with 234.
I'm referring to for respondent, private respondent.
No. This Wakalatnama shows that you are appearing. S.K. Goswami, B.K. Goswami, and A. Khalik Kolita. This Wakalatnama has been signed by the chairman, Nalbari Municipal Board.
Earlier municipal board has been no customer, because thereafter of the right of contact with
Huh?
municipal board, earlier municipal board said.
But what is this? When the authority and the private respondent together appears by the same counsel?
Only thing is, also, I am referring to now at present my.
No, now forget about that. You have already signed your Wakalatnama earlier. Okay?
My case is totally like this.
I am not on other thing. Your case is, how is the private respondent and the municipal board appearing by the same counsel? How is it possible? And thereupon, have you issued any notice to Nalbari Municipal Board? Where?
I have informed them that under record of stay.
Huh?
I have informed them after immediately sent to the municipal board, I have informed my people.
Where is that?
I have informed by the report.
No, Mr. Goswami, this is a very serious thing. Because if you have informed, because how, without that intimation being given out here in the place before this court, becomes very difficult. No, you have to. And then only you could have appeared for 4. Otherwise, it shows the collusion between the municipal board and you.
I have already informed them.
No, this has a very serious notation. How can you appear for both? And the municipal board, this action that means must have been done in collusion between the respondent number 4 with the municipal board. If it is the same council, that is the only analogy one can draw.
Cases like this.
I am not on other case. This is the case. Here is a case where the petitioner is alleging that without him being put to notice,
Without notice.
you have done that.
Without notice, he has done, that is the allegation. Without notice, that has been done. My case is proceed.
Your case means whose case?
For private respondent.
No, you can't be private respondent. You are with the municipal board. Then if the private respondent and the municipal board are appearing together, isn't it shows that it is a collusion? And that is what the petitioner has been alleging, that there is a collusion between the private respondent and the municipal board is proved. And then wakalatnama has not been withdrawn.
I have informed.
No, you have not withdrawn the wakalatnama. Can you withdraw? No, as per the Guwahati High Court rules or even as per the Advocates Act, can you just inform over the telephone and say that, look here, I don't want to? No, not possible. Then this has a very serious connotation as you regards you. What to do?
I listened. I listened. Regarding it.
There's a stay. Have you got any interim relief?
No, no.
This delay is going to hamper him. And we have to hold it, that there is a collusion between municipal board and the respondent number 4. And as such, that order has to be set aside. Remaining is the municipal board may do independent of what. It is the only way. Very serious.
I take acknowledgement from them regarding, I have earlier informed you, but regarding the chairman of the municipal board and I took it here. I have already informed us.
But Mr. Goswami, I think you should not appear for both now.
Yes, I did.
You should withdraw the wakalatnama for both, ask them to appear through some other council. Because here there is a direct conflict.
Next week, I will give I will produce the notice by acknowledging it.
You should withdraw for both, because this may be very detrimental. And that too, most interestingly, this wakalatnama filed on behalf of the respondent number 4 is on 2nd of April 2018. And knowing fully well that you are representing the respondent number 4, who is a private respondent, you have chosen to appear for respondent number, the official respondents.
Earlier, I was preparing for municipal board. That is why-
No, not earlier.
No, I
For municipal board, the wakalatnama is of 3rd of May 2018. That is more serious. This is not earlier.
No, earlier cases, I have.
I'm not concerned.
That is why they have said.
Are you a standing council of the Nalbai
Not
municipal?
pending of, but they have engaged me and earlier.
Maybe, but here you have signed a wakalatnama. The wakalatnama is dated 3rd of May 2018. After you have entered in appearance on behalf of the private respondent, then how can you do that? Unless the municipal board once has a collision between the municipal board and the respondent. And the
I will give a separate notice to both of them and I will. publish.
Mr. S.K. Goswami, the learned counsel, submits that in view of the wakalatnamas dated 2/4/2018, signed for and on behalf of the respondent number 4, that is the private respondent, and the wakalatnama entered into and the wakalatnama dated 3/5/2018 for and on behalf of the respondent number 2 and 3, whereby he, along with 3 more councils, have appeared before on behalf of the respondent number 2, 3, and 4, would like to withdraw the said wakalatnamas for personal reasons, and as such seeks an accommodation to file to inform the said respondent numbers 2, 3, and 4 to list the matter again. On the other hand, Mr. D. Chaudhary, appearing on behalf of the petitioner, submits that there is an urgency in the matter. Taking into account the above, list the matter again on 22nd of November 2023. Yes, government, what is your stand? Huh? Anybody notified that you, that the demarcation will come in month, the land will be none appears on behalf of the petitioner on call. This court fixes the matter again on 17th of November 2023. It is made clear that if the petitioner is not represented on the next day, the instant petition shall be dismissed for non-prosecution. Taking into account that the petitioner is not represented, this court is not inclined to extend the interim order.
22 to 24.
Yes, what is this?
We have the landowner. If we are the landowner. My lord, that in our land, my lord, that the proposal to set up a checkpost.
Set up a
Integrated checkpost.
check post. Taking over the land of the super. So you want, your simple thing is, if you want the land, acquire it.
Why are we want compensation?
Acquire and pay compensation. Have they acquired it?
No,
So they have, however, taken over the land.
no.
Then what do you want?
Because there is an order, my lord, they are trying to set up this checkpost.
Check post. Check post over your land.
Our land.
Okay, we direct them not to hold the check post in your land without acquiring the land. That's all. That is the only thing.
If they want to acquire money, there is a necessity.
Huh?
They are
If they want, they will, but not to disturb your possession unless you take steps. Who is on legs? Okay, go away. What happened to you? What is your stand? And why are so many repetitions? Huh? So no land has been acquired. No land possession has been taken. But the only worry about is that if they take over the possession, they have to acquire it and pay you compensation. That they will do. Why will they? Yes, madam. Huh?
the rest of the drag river, for the large area of India, including my left, the name of the restaurant of the state. We want to use the without my knowledge.
Madam, you kindly come this side. Yes, madam, come here. Which writ petition you are appearing?
5.
4, 6. Yes, tell me. Please the matter on which state the deputy commissioner shall place the records in original pertaining to the land acquisition at so and so in the Karimganj. LA case number 21, 22 and this. So there has been acquisition. Why is he saying that there is no acquisition? Possession is with you, but the acquisition has happened. Records are? You've got the records? Give it to me. Mr. Hending was appearing on the last occasion. Madam, award has been passed. Have not received the compensation. Then go there. This is done under section 12. Award has been passed, everything has been done. How can this court decide whether you are entitled or not? Understood? Liberty, I will give you. Move under section 12. This is done under the 64 Act. Because here, you see, as I could see, this is in respect to which case? LA case number 4/2015-16. This is LA case number 1617 or what is this? 4/1617. Then in that case, award has been passed. On receipt of the approved award dated issued to the Pattadas concerned for receiving payment of land compensation. Land compensation has been paid. Total amount which have been paid to the government is has been deposited by the authority is 4,18,56,979, and name of the page amount is there. Some have lodged FIR and some have moved the writ petitions. You agree? Move under section 12. That is the only way out. Ask the collector. What is this code going to?
Here the original owners. Some are minus fraudulently mutated our debt.
Understood. Everything is understood. But can this court decide that you are the original owners or not? Tell me. No. It will require a fact-finding inquiry. You have the 1964 Act with you, or have approached this court without an act? I did you 64. Yes. 64 Act. Volume 1 of this. Okay. Volume 2 this. 247. See section 12. Twelve one. What does it say? Let us hear it aloud. Yes, yes.
Any person paid by an award made under subsection 3 of section 11 makes an application required in the letter to the department of court.
Then
Then where there is an execution with regard to the compensation payable under subsection 4 of section 11, the application of the person entitled to compensation requiring the matter to be referred to the court.
so require the entitlement. So you have to move the collector.
Collector is referred to.
That is the only way out. This court cannot do anything. This court, as of now, the award has been passed. So I can't direct the collector any further. But the moment there is a dispute, you bring it as regards a particular land, then you see this very provisions, 12.2, read 12.2.
Subject to the provisions of this act, the provisions of the Land Acquisition Act 1994, that shall maintain notice apply in respect of any reference made to the court under supplemental law.
Now what happens? In view of that, you have to apply rule section 18, then 30 of the Land Acquisition Act 1894. And 31(2). 31(2) says, the moment you raise the dispute, the collector shall deposit the amount, if not disbursed, before the court. See? So you have to do those. Nothing to do with this court. This court has nothing. This court can't decide anything.
My submission, madam.
Yes.
In this case, it is admitted that our land is permanently located or award merit pass for comparison maybe given. I'm not on that. Consider our expense matter. Your worship may direct the collector that after disposing these our grievances, right? Then award can be given to the originator. Then comparison can be given to the originator. But after following all the procedure, as decided by this act, that our grievance will be taken up by the collector. Collector may refer to the court, and then court may decide who are the original owner. Then the matter can be decided. That can be done with the state from the document.
I can direct.
And I think the document directly.
Fantastic.
So that my lord, at least our we can be protected by it. Otherwise, my lord, in the whole procedure, my lord, since 2012, since 2012, the circle officer, the deputy commissioner, all others, my lord, engaged in their activities, criminal activities, several criminal cases pending. The inquiry was made done by the CBI. Either the whole our land, my lord, the whole area of our land, my lord, whole land has been located for the. Consider that aspect, my lord.
Possession has been given to you.
We are not able.
Here the record says that annexure 28, possession has been given to you.
Not the first person. We can put-
Here it says possession has been given. Yes, certified that I, on this day of 7th of January 2017, received possession from the land of hands of Sri Esau Gohai, with a who I. Possession received it by Section Officer Project, Land Ports Authority of India, Government of India. Then, what is this possession? This is 4 kathas. This is 4 bighas, 4 kathas, 1. You don't know how to write English or English. 4 bighas, 4 kathas, 1 chatak, 1.39 R. Yes.
Regarding that,
Acres. If that has been, this possession has been given.
I will let kindly.
No. I'll see the records. Why will I go into all these things? The record shows you have some person out here, Dilip Kumar PB, Section Officer Projects. And then this is being countersigned by Roshan Lal, Consultant, Land Ports, Ministry of Home Affairs. Signed it. And further countersigned by Koi Commander, 133 BN, BSF. All have signed it. And on the other hand,
Because there is one criminal case also. We have continuously written to the authority, the peaceful and our that was not done. The court says that proceed, otherwise what proceed, we cannot proceed further also.
no, as of now, once the land award has been passed,
What past, we have also.
the land rests upon the state. free from all encumbrance. So under such circumstances, that is the law.
And compensation amount also released from our part and that was also released by the.
Here also another position taken, 11 bighas, 5 katha, 7 shataks. This is also received in 2017. So, Mr. Counsel, what do you want? Yes, madam, what do you have to say? So,
And some other.
no, understood. Everything is understood. Other person's name has been mutated or whatever may be. But the fact is that, how can this court decide? I'm not concerned about the affidavit in opposition, but the question is, once that has already been done, the award list having been prepared, put to signature, can this court direct against the deputy commissioner to re-look into it? No, he has already, yes, award passed, everything has been done. There's nothing remains. And as per records, possession has also been handed over. As per records, possession has also been handed over.
They have stated that by intention, lands were recorded to the legal heirs. This is some record.
I'm not on that. Why will this court decide all these things? I'm not going to decide all these things. Why do you need a title suit for? You claim a particular amount.
No, but I'm not claiming it.
No, you will be entitled to some amount if your land is acquired.
Award already been passed for it. That was passed in favor of the third party. Some other person has taken that out.
No, in respect to the lands. In respect to the specified lands, the awards have been passed.
Who has received?
Huh?
Who has received? In which favor the amounts were?
Amounts have been paid to various persons. That is what has been mentioned. Huh?
The entire our lands, we were the recorded Patra holders. I have an all the Patra with my restriction and subsequently some.
Okay, you want this court to decide? Chalo. Which item is this? 4651? Which writ petition is yours? Item writ petition? No, let him die, no problem. But the question is, which writ petition is this?
4651.
4651, yes, come, tell me, where?
Annexure 1 creating the name of the petitioner.
Annexure 1,
Yes.
okay. This patta was issued when? Who has issued this patta? Who has issued this patta? Whose signature is there of this patta? Where is the original patta? Show me. You want this court to be the question of facts? We'll look into it. Whether there has been a transfer of the land in the meantime. No, madam, you want this court now to act as a court of facts. You can't be on the basis of information. You have to go as per reports. Now show me this. Else I dismiss your claim here. I will go on the question of facts now. Show me. I'm not concerned. You are to produce. If this court is to decide, then this court has to decide on the basis of the facts. Absolutely no. The deputy commissioner is functions official. The deputy commissioner as of now has no business. The only person who has the business is the district judge. That's all. That is what I have been asking you all this time from the beginning. You want this, all these things, this court should decide all these things. How can this court decide? All this while I've been asking your junior to do that, and where Ms. Astra has duly agreed. To take you. The three petitions are taken up together for disposal by this common order. Are all these petitioners pattadas? Are all these petitioners pattadas? The petitioners hearing, the case of the petitioners hearing. Now, are all the petitioners pattadas or the petitioner predecessor in interest were issued pattas? You are the successors. The petitioners in the three petitions are either the patta holders are either have been either issued periodic pattas or are or successor in interest of those persons whom periodic pattas have been issued by the respondent, by the concerned respondent authorities. The lands of the petitioners have been acquired by the respondent authorities under the provisions of the Assam Land Requisition and Acquisition Act 1964. The lands of the petitioners and along with other lands have been acquired under the provisions of Assam Land Requisition and Acquisition Act 1964. The same land acquisition proceedings in three land acquisition proceedings, that is LA case number 21/2015-16, LA case number 22/2015-16, and LA case number 4/2016-17. At this stage, this court finds it relevant to take note of that by an order dated 25/9/2023, this court directed the respondent authorities to produce the records of the three land acquisition cases. And accordingly, Mr. J. Hendy, the learned counsel appearing on behalf of the collector, Deputy Commissioner cum collector, which one? Kachar? Karimganj, have produced the records of the three land acquisition cases today. From the record, before dealing with the records, this court finds it relevant to observe to take into account the grievances of the petitioners. It is the case of the petitioners, as could be seen from the writ petition, from the writ petitions, that the lands belonging to the petitioner were fraudulently mutated by the concerned respondent authorities in the names of some other persons, and thereby the petitioner's rights to claim compensation have been deprived. It is the further case of the petitioners that time and again the petitioners have represented before the Deputy Commissioner, come Collector, Karimganj. However, nothing has been done in that regard, for which the petitioners have been compelled to approach this court by filing the writ petition. In the backdrop of the above, let this court therefore take note of the facts involved, the facts which could be discerned from a perusal of the records. It is seen from the records that all the 3 land acquisition cases have been registered for acquisition of land for the Land Port Authority of India, bracket LPAI, bracket close, Ministry of Home Affairs, New Delhi, for construction of integrated checkpost at Sutarkandi. The record further reveals that in respect to LA case number 21/2015-16, the land which had been acquired was proposed to be acquired is 11 bighas, 5 kathas, 7 shataks. In respect to land acquisition case number 22/2015-16, the land proposed to be acquired was measuring 4 bighas, 4 katha, 1 lecha, 1 shatak. And in respect to land acquisition case number 4/2016-17, the land proposed to be acquired was 30 bighas, 8 kathas, 14 shataks. The records further show that in respect to the 3 land acquisition proceedings, that the same 3 land acquisition proceedings were initiated under the provisions of the Assam Land Requisition and Acquisition Act 1964, for short, the Act of 1964. It is also seen that the respondent authorities, that the office of the collector Karimganj have taken certain steps have taken necessary steps for the purpose of arriving at the proper valuation of the land. On the basis of the said valuation made in respect to the plots of land, land acquisition estimates were acquisition of line to
On the basis of the same valuation made in respect to the plots of land.
had taken various steps for the purpose of ascertaining the market value of the lands. It is also seen that the assessment, land acquisition assessment was made in terms with the provisions of the Right to Fair Compensation and Transparency Act 2013, for short, the Act of 2013. On the basis of the said land estimate prepared. The same was placed before the LPAI for release of the necessary funds. The record for the reveals that the LPAI had, on the basis of the said requisition, have deposited the said amounts before the collector, Karimganj, by demand drafts as far back in the year 2017. It is further seen that the final LAS estimate, along with the connected LA papers, were sent to the government of Assam Revenue and Disaster Management Department for necessary approval. The approval was duly granted by the Revenue and Disaster Management Department of the government, and on the basis of the same, the awards were filed before and on the basis of the approval, the awards was passed in respect to the 3 LA cases. And notices were issued to the recorded pattaras concern for receiving the payment of land acquisition compensation. Pursuant to the issuance of notice, claim petitions were duly filed by the pattaras. And after making necessary verification, the additional deputy commissioner ordered to release payment of compensation on the basis of the documents, receipts from the pattaras and the circle officer office, Karimganj. The above, that the materials show placed on record, that the materials which could be discerned from the records, therefore shows that the award has been duly passed and certain payment of compensation has also been made. However, it is the specific case, be that as it may, it is the specific case of the petitioners, that they are the persons interested and accordingly ought to have received the said compensation. At this stage, this court finds it relevant to take note of Section 12 of the Act of 1964, taking into account the relevance of the said Act, said provision, the same is reproduced here in under. From a perusal of the said section, it reveals that a person, if agreed, reveals that any person aggrieved by an award made under subsection 3 of section 11 has a right to make an application requiring the matter to be referred to the court. Further to that, the question, if there is a disagreement as regards the entitlement of the compensation, it is seen that it is only the court who can decide the same. And under such circumstances, when a person applies before the collector is under a statutory obligation to refer such matters to the court. It is also relevant to take note of that section 2B of the Act of 1964 defines the term court to mean the principal civil court of original jurisdiction. Subsection 2 of section 12 of the Act of 1964 further stipulates, by legislation by incorporation, on the basis of the principles of legislation by incorporation, incorporates the provisions of section 18, section 30, and section 31 of the Land Acquisition Act 1894 to the provisions of the Act of 1964. Under such circumstances, by virtue of section 12(2) of the Act of 1964, read with section 30, read with section 18 and 30 of the Land Acquisition Act 1894, what transpires is that a person, if he is agreed by any, as regards the apportionment of the compensation or as regards the entitlement of the compensation, has a right to apply before the collector. And the collector in such circumstances has a statutory obligation to refer the matter to the court. So, under such circumstances, this court is of the opinion, under such circumstances, taking into account the grievance which has been sought to be ventilated, the grievance, under such circumstances, taking into account the grievance of the petitioners, that they are actually the person interested and not the persons who have received the compensation or whose names have been put in the list of the beneficiaries. The petitioners would be well advised to approach the collector, that is the district commissioner, collector, Karimganj, in terms with section 12, making an application, seeking a reference to the court. It is made clear, it is observed and directed that in the eventuality the petitioners approaches the collector, oblique the district commissioner, and the district commissioner collector of Karimganj, the said authority shall forthwith refer the said application to the district judge, Karimganj, to decide as regards the entitlement of such petition of the petitioner. How much time we are going to take for filing? This court further grants 30 days to the petitioner to file the appropriate application. No. Because here again the problem arises in the limitation. You say this court has to give you the limitation because as per section 18, it is 6 weeks or 6 months from the date if you are not a party to the proceedings. So it is otherwise over. Because the award passed in 2017. So now if you want to do it, this court is giving you. And again, this court further taking into account that the petitioners have all along been fighting, have been diligently and bona fidely litigating as regards the claiming the entitlement, grants 30 days of time from today for the purpose of filing the necessary applications before the collector, the district commissioner from collector, Karimganj. Further to that, this court also directs that in the event the amount of compensation to which the petitioner claims to be entitled to in respect to the land having not been disbursed, the same be deposited before the reference court. With the above, the instant petition stands disposed. The records to produce are returned. Yes. Anything more?
We have already given the amount.
No, not for you.
Plus,
No, if they have not disbursed in respect to the lands of the petitioner, be because that is the mandate as per 31. I've given them 30 days.
Regarding
It makes a reference. I've said that if they make a reference,
then
once they file the application, that amount, if not disbursed by them, shall be deposited before the reference court. These were all the petitions accordingly.
I have to submit one. And one submission. Till then, my husband may not be disposed. Before that is for this, application to be final.
Mr. Counsel, the moment an award is being passed, the more it is, the land would automatically vest upon them. You have no right. But from perusal of the materials, I think that your lands have not been touched because possession has already been given to them and they have already taken possession. Apart from that, another very relevant aspect which I could see is the possession which have been given to, they had exercised section 9. 9 is an emergency power. Emergency power means possession will be first taken prior to the award, meaning thereby the possession must have been taken. So you may not even be affected. That is why you have not got the money. That is why you have not been dispossessed. It seems something like that. I'm not gone into, because if I go out there, it will have efforts which will consider.
25
That's it, I'm finding it. Even we are ready to get.
Oh, R. Goswami, the learned counsel appearing on behalf of respondent submits upon instruction the respondent is willing. I have asked you to file an affidavit. Where is that affidavit filed on the B? So, in view of that affidavit, nothing. Dekho. The instant repetition was filed by the petitioner being aggrieved at the non-settling of the claim of an amount of rupees 15 lakhs by the respondent number 4. On account of the death of the policyholder in the road traffic accident. When the matter came up before this court on 25/9/2023, the learned counsel appearing on behalf of the respondent number 4, Mr. R. Goswami, had verbally submitted that the respondent was willing to settle the matter with the petitioner. Taking into account the said verbal, taking into account the above, this court directed the respondent number 4 to file an affidavit in that regard. Accordingly, on 10/10/2023, an affidavit has been filed by the senior manager legal of the respondent number 4. Paragraph 2, 3, 4, 5, and 6 being relevant of the said affidavit is reproduced here in under. Taking into account the above stand of the respondent number 4, more particularly, that the respondent number 4 would pay the amount of rupees 15 lakhs within 6 weeks of the receipt of the order of this court. This court therefore directs the respondent number 4 to pay the amount of rupees 15 lakhs to the petitioner within 6 weeks from the date a certified copy of the instant order is served upon the branch manager. Branch? Upon whom? Huh? Whom should it be paid, submitted? No, that is a difficult thing. You have a branch here. He is going to go there. Huh?
I will send it by speed post.
No, she is directed.
So therefore, direct the respondent to pay the amount of 15 lakhs to the petitioner.
Petitioner within 6 weeks from the date within 6 weeks from today. The registry is directed to serve a copy of the order to Mr. R. Goswami, the learned counsel appearing on behalf of the respondent number 4 to effect due compliance. The petitioner, I think that is enough. With the above the instant petition, observations and direction of petitions are disposed.
And about 35.
Except.
There's five of these very fine relates to the electric or one of it. There is two of these petitions.
Yes,
Relates to the system, the electric from one to seven.
Huh?
Serial electric.
are you saying that till now, this is nothing has happened out here in LA case number 1 of 2011-12? Hmm?
But thereafter, after creation of new district, they have initiated the process.
This one,
My God.
1 of 2016-17. Because obviously, if it is 1 of 2011-12, and you have not culminated till now, so that has already lapsed. So this will be the concern.
I don't have then instruction here written instruction whether this land acquisition cases are same or different matter. So this record will be called for I will be there sometime for verification of this.
Because of that, there was extra process for Samai bill.
Huh?
Electric number 151 of the relevant field. Work for.
To acquire land speedily for works or other development measures or in connection with flood control or so and so, and therefore, under section 9, the governor is pleased to order the land experts were measuring so and so. Man is for man.
Addition of land is 4 meters.
Hmm?
Extra land of it is 4 meters. And they are not. This report will be the. Agents of various. Then was looking for Tamari and by the scheme. And these estimates was looking for Kalu, FIS and Ramani.
Madam, what has happened to the land case number 1/2011-12? You are asking for whether your land was acquired, taken over. Are you in possession of the land? Who is your senior? Who is your senior? But madam, there has certain correspondence by which you say that that land acquisition case of 2011 was stalled. This is of 5th of April 2023. But there, in the year 2015 itself. But there are certain documents by which you are still going on for hearing. Here you have issued it to the petitioners on 15th of September 2022. I am to inform you the land acquired for construction of Samay Bill FIS headwork in respect of LA case number so and so about Patadar or village in this year, a hearing is required. You are requested to attend the office and bring records.
Document for documentation part, they need some cooperation on the part of people and
What was the land acquisition case number? 1/2011. But the documents which you placed on the last occasion relates to land acquisition case number 4/2011-12. We are concerned with 1/2011-12.
that is something that
Huh?
I tried to acquire incurred accordingly. So I need some time to clarify this and find a detailed application.
These are all 4/2011-12.
Either after application or then
Hmm?
but they do have mentioned about one of the 11.
4/2011-12. Whereas the petitioner's case is 1.
Which deadline?
Which means the deputy commissioner have not done anything, or have you done away with the acquisition?
That activity is presented as a simple-
No, these are different.
That is what it- whether it relates to petitioner's case or some other case waiver. That is not reflected from the.
The instant writ petition was filed by the petitioner, by the petitioners, claiming compensation and being agreed by the non-payment of compensation in respect of LA case number 1/2011-12, whereby the petitioner's land measuring 4 bighas at village Samaibil in Mankasa Revenue Circle were acquired for providing irrigation facilities. On 9/10/2023, Ms. M. Burman, the learned government advocate, had placed an instruction which had been kept on record and marked with the letter X. In the said instruction, it has been mentioned that the assessments were duly done and there was a request being made for payment of compensation. And a request was made for payment from the irrigation department of an amount of rupees 10 crores 62,74,443 to the Patta awardees in respect of LA case number 1/2016-17, LA case number 2/16-17, and LA case number 4/2011-12. This court further finds it relevant to take note of that there is also an instruction kept on record dated 5th of April 2023, wherein the Additional Deputy Commissioner South Salwara Mankasar had stated that the land acquisition case, that the acquisition of land in the year 2011 in Samaibal Revenue Village in respect to the lands belonging to the petitioner and 6 others, though was initiated, but was stalled in the year 2015 without any steps taken by the then administration. It was further mentioned that the acquisition process was stalled without any reason. Pursuant thereto, in the same instruction, there are certain communications to the effect whereby the Additional Deputy Commissioner cum Land Acquisition Officer South Salwara had directed the Assistant Settlement Officer Mankasar Revenue Circle as well as the Executive Engineer Mankasar Division Irrigation to carry out a joint survey There is also a communication by which the Additional Deputy Commissioner South Salwara Mankasar has sought the appearance of the petitioners along with other persons for hearing in connection with LA case number 1/2011-12 as regards the acquisition of land from Samaibil FIS. Mr. N. Upaidya, the Standing Counsel of the Irrigation Department, submits that the instructions which was placed and kept on record by marking the same as with the letter X has no relation with the LA case number 1/2011-12, which is the subject matter of the instant proceedings. Ms. M. Borman submits that she would take appropriate clarifications in respect to the said matter and place the instructions as to whether the land acquisition LA case number 1/2011-12 and place appropriate instructions as regards the status of the land acquisition case number 1/2011-12, that's 12. On the next date. List the matter again on 8th of November 2023 for further consideration.
I think item number 2.
Yes.
Subject to the not instruction to allow that or close that with the liberty to pursue the representation. I mean, it can be reserved, it can be a future.
The instant writ petition has been filed by the petitioner, being agreed by the inaction on the part of the respondent authorities in not considering the representations dated 22/1/2018, 25/1/2018, and 29/1/2018, as well as 18. The petitioner have also challenged have also sought for direction to the respondent authority to dismantle the structures constructed by the private respondents over the land allotted for bus stand, which interferes with the right of the petitioner for peaceful occupation and enjoyment of land, and accordingly further have sought for a direction to the government authorities to place the private respondents at the correct place, that is in the southern side of the bus stand area on the row of the constructed market shed as revealed from the RTI reply dated 21/2/2018. The private respondents, pursuant to the filing of the instant writ petition, this court passed an order on 12/4/2018, whereby notice of motion was issued, and there was a further direction that until further orders, the private respondent shall maintain status quo with regard to the land allotted and shall not raise any construction and use the land for any purpose. The private respondents have filed an interlocutory application which have been registered and numbered as ISC number 2660/2018, seeking vacation, modification and or alteration of the order dated 12/4/2018 on the ground that the said land have been allotted to the petitioners, have been allotted to the private respondents, and as such, the interim order which have been passed directing the private respondents not to use the same land and also to raise construction affects their rights over the land which have been allotted. Mr. So-and-so, the learned R. Islam, the learned counsel appearing on behalf of the petitioner submits, on behalf of the private respondent submits that the entire basis of the case of the petitioner is totally, the case of the petitioner is totally unfounded and misconceived, taking into account that the petitioner has filed the case on the basis that the land wherein the private respondents are occupying and has raised construction is a land allotted for bus stand, which is on the face of it erroneous, taking into account that the said land have been allotted to the private respondents. The learned counsel further submits that the land that the petitioner have also not challenged the said, have not challenged the allotment orders, and without the challenge, the instant writ petition cannot be maintained. Mr. Esponek, appearing on behalf of the respondent, the petitioner submits that the petitioner has a land on the behind the land wherein the private respondents are occupying, and as such occupying and have raised constructions, and this has affected his rights to enjoy his property, as well as has affected his ingress and egress to his property. Because he submits that he may be permitted to challenge the allotment orders which have been issued in favor of the petition, private respondents. Because taking into account that in the instant writ petition, this court have heard the learned counsels for the parties and have perused the materials and reports, taking into account that the entire basis of the case set out by the petitioner is on the basis that the petitioner, that the private respondents are occupying lands which have been occupying and raising construction of the land which have been allotted to a bus stand. And the same being misconceived, this court cannot permit the petitioners in the instant writ proceedings to change the nature and character of the writ petition by permitting the petitioner to challenge the writ petition, the allotment orders. Accordingly, as the edifice of the petitioner's case no longer exists in view of the allotment orders issued in favor of the private respondents, this court finds that the writ petition is meritless, for which is devoid of merits, for which the writ petition stands dismissed. It is, however, made clear that the dismissal of the writ petition shall not preclude the petitioner, if so advised, to approach the respondent authorities, as well as also challenge the allotments so made in respect to the private respondents. With the above, the petition stands dismissed, subject to the observations made in the penultimate paragraph. I still closed in view of the order dated. The interim order passed earlier stands.
26.
No PWD. Yes, Mr. Nayak.
In this case, can you?
Not necessary. Verify.
Yes, that case, but
Verify and pay. If no payment has been made.
that second engineer will verify that.
Verify. Chief engineer will verify and pay. PWD and as per terms only. Verification within 1 month. And payment as per terms. It will hit the order this, no? The rest. Yes, Mr. Srinivas. Huh?
Affidavit has been filed by the state.
Yes.
That relates to-
The next meeting of the advisory. You have filed an application for settlement.
Yes.
That has not been,
Considered by the land.
now land policy 2019 has come. You file it separately. This becomes useless. Nowadays, the parameters are different.
Flexibility is there, but even otherwise, if the land policy of 2019 is taken into consideration, then also will find that the petitioner satisfies the
Huh?
that the petitioner satisfies the eligibility criteria to take down the policy.
Which I can't decide. Let them decide. You file an application of this as per the present land policy.
Visual land.
Huh? Oh, visual land,
Page, paragraph 7, page 25.
7 page.
Land in question, possessed by the petitioner.
Following basis, the certified that demand upon the omission of the subdivision will be released. Where? Paragraph
Second.
7 doesn't say anything. The following the passing of the aforesaid order, the petitioner serves certified
Deputy
copy.
Commissioner's affidavit, talking to-
Oh, Deputy Commissioner's affidavit. Yes. What is this land?
Land in question, possessed by the
The
petitioner.
land in question possessed by the petitioner measuring so and so, covered by so and so under VGR reserve area. At present, there is no provision of allotting reserve to any individual as per the Supreme Court judgment. in case.
I don't know, refer to an affidavit, my lord. My problem is mine that their stand, it's contrary to what the documents are required.
Hmm?
The document is trying to weigh. Page four of their affidavit.
Hmm. Yes.
Status of the land has been given there.
Hmm.
And my lord will see the lecture.
Hmm.
Whether land reserved or not, it was something that was not very clear what they are the next. It indicates that there is no reservation. Land is not reserved.
Where?
It's-
Show me,
it's-
show me the,
I-
no, no, no,
I look at-
no, Mr. Srinivasan, show me that particular document on which wherein the chita or the jamabandi of that land. Where is it?
My lord will go to page 5.
Huh? No, no, if it is a VGR land, the question of allotment does not arise. Matter ends there. You may apply, you may go to some other place, but not VGR.
My lord,
If you come within the ambit of a landless person, very well. And you may get some other place, but not VGR. VGR is out of question. And in fact, the land policy on,
for the 19 months, I understand that, my lord. But their own documents say that it is not reserved.
which document?
On
No, the page
of
4,
their affidavit.
no, page 4.
Page 4.
Page 4 and the annexure to it.
Well, what does it say?
It is the last part, my lord. Whether
Ah.
it's reserved, it is not very clear, but it says no.
No, no, present status of the scheduled land, it is a VGR reserved. Page 4 of the affidavit, annexure 1.
The annexure doesn't say so, my lord.
What doesn't say so? You are holding a different type of annexure, I suppose. Am I holding the same requisition, WPC number 2029 of the 2021?
Yes, my lord.
And what type of, what affidavit you are referring to now?
The government affidavit that the annexure 1,
Then,
annexure 1, 3, 4, and 5.
I'm not saying about the 5. What is this 5 has to do?
But I indicate
No, page 4 categorically, no, Mr. Srinivasan, page 4 categorically says it is the VGR reserved. What else is required?
says whether reserved or not, it says no.
Where?
Where the page 5, page 5.
Where is it? Whether
Right
reserved?
right at the bottom, right at the bottom. Last line. Whether the,
No, this is,
Because
no, this is a different plot of land of 28 because we are not concerned with this land.
that is,
We are not, but this document at page 4 categorically shows, it is a part of it, that document.
yeah. Other than that,
No, Mr. Srinivasan, kindly see page 5. How does page 5 come in? Kindly see page 4, the last line. Enclosed copy of land bank of the scheduled land. Here it is a different thing, where it has been shown to the report year 2009, Maguli, dark number 14, and 28 bighas, 2 kathas, 18 lectures, no class, weather reserve. Then
no class of land, no class, and then there is the next part. Whether taking this place. Indicating whether it's reserved or not. And say no.
Here it is mentioned 2, 3 kathas, 10 lessons is VGR.
But one of the facts will remain that there is an order of this court directing the authority to consider my application.
But whether merely it is a direction to consider, nothing more than that.
That is one of the fact remains that the land advisory committee meeting has never been held, they have never considered my application. That is the only limited results.
No, now the question of consideration, if it is a VGR land, doesn't arise.
But my lord, even that.
And as of now, and as per the present land policy, you are now to go as per the present land policy, you have to apply out there.
The land policy, whether it falls within the land policy or not, is still it is in the domain of the land advisory committee. So, should you direct them?
Show me where the land advisory committee, as per what provision you are bringing the land advisory committee, under what provision?
It has been going on now.
No, forget about going on, Mr. Srinivasan, but question is, how, on what basis are you saying about the land advisory? It is just an executive instruction that there will be a land advisory committee who will look into this, make a recommendation to the deputy commissioner. Deputy commissioner will make the proposal to the government, and the government will approve the same, and then the government deputy commissioner would give the, this is the manner in which it's to be done. But if there is no right on the basis, even the land advisory committee, I say, let us assume the land advisory committee has given a report recommendation in your favor. Do you have a right over it? No, you don't have a right. Even if the governor says that yes, the land has to be allotted to him, unless as per the rules, the settlement is not being granted to you, you have no right. And this is a VGR land. I can't help you.
Yes. Yeah, I have tried to be. They have been doing a lot in the same area, at the same time.
So,
So, my lord, I think.
no, if they have been given this, do you want that this court should exercise the negative equality? That would not make your case out there. That has nothing to do. The land, it is clear from the affidavit out here, that is a VGR land, nothing. The question of you being given in view of the Supreme Court categorical judgment in Japal Singh, nothing happens. Can't help it. And apart from that, your entire basis, when did you file the petition? 2021. And when did you file your application?
Much before that.
Then, if you have done it prior to that, now 2019 policy has come in. Now 19 policy stipulates a different thing. The manner in which it is to be applied, everything is different. But VGR land can't be allotted even as per the land policy of 2019.
That is a.
Huh?
He reserved the land.
He reserved land.
He reserved the land.
My God, it is too much.
Not a thing that it goes to. I will be at least allowed to, in view of the fact that I've been in occupation of the land. since 1980.
Better off, Mr. Srinivasan, withdraw the petition, approach the authorities. The authorities may give you more relief than what I am doing. I am only going to dismiss it and saying that it is the reserved land, and as such, the question of allotment of that land cannot be given. But that would be more disastrous to you. You may get some negative equality from the authorities, not from this court. Then what do you want to do? And approach the authorities. And then Mr. T. N. Srinivasan, the learned counsel appearing on behalf of the petitioner, submits that taking into account of the land policy, I just put it like this, the land policy of 2019, he would not like to press the instant writ petition, but would rather approach the respondent authorities as per the extant land policy of 2019. Taking into account the above, the instant writ petition stands closed on withdrawal. The withdrawal of the instant writ petition shall not prejudice the rights of the petitioner to approach the respondent authorities. Yes,
Purchase one kata 12 letters. Perhaps some Sita mutation has been also granted. After he constructed his house upon permission of the company. And founded was also funded. Thereafter, when we collected the certificate of the Jama, 6 letters of own land reduced my loss from this land. My loss.
6 letters reduced.
Reduced my loss without any giving any notice that 6 letters not requisition my lord, not required my lord. And we filed a special application for the.
Where is your allotment? Oh, you have purchased.
Parcels, my lord, parcels. Then
You have purchased how much? 1 kata 12 letters. And then this is to certify that so and so is covered by so and so on so and so. At present, resettlement is going on and mutation process has not started. Is what is being done by the settlement officer. Is to certify that 3 letters of land covered by so and so, and 1 kata river of land of so and so in the name of Banikanta Das in place of so and so. Then this is only issued as a preparation of so and so.
in the beginning of my application, one mistake.
Then
also
you
is
got
on
your
the
construction.
express.
And where is the now the present thing?
There is no time policing the land, my lord.
Office of the register, 3 letters of land. Certified that the property situated below has been searched in the so and so Iman. We have 1 kata 9 letters. Oh, 3 letters is gone.
6 letters, man.
3 letters. 6 letters from where?
So the two pattam and the two dark.
2 darks, 3 letters each.
Yes, my lord. From one dark, 3 letters, my lord. In that dark.
And you have come to know from the search, non-encumbrance certificate. And then you have asked them for collection, correcting.
Correct, my lord.
And what has happened? They have not done it.
On the mistake of.
Yes, why have you not done it? Do something.
Mistake number, my lord. Mistake also PRN 144/2014 was also. Registered.
Directly.
Authorities considers.
The instant petition has been filed by the petitioner being agreed by the inaction on the part of the respondent number 3 in not disposing of his application for correction of the land records, which have been registered and numbered as case number KRC bracket M/144/2014. From a perusal of the materials on record, it reveals that the petitioner had purchased a plot of land measuring 1 kata 12 letters situated at village Gotanagar, covered by KP Patta number 163 and 165 of Dag number 346 and again covered by Dag number 346 and 348 included in KP Patta number 163 and 165 under Muza Jalukbari in the district of Kamrup, Assam by the registered sale deed bearing deed number 26/2/1998. Pursuant thereto, as the settlement operation was going on, the assistant settlement officer had also given a certificate to the effect that the petitioner is the owner of the petitioner name have been included in the said DAGs. Have been included, the petitioners had or given a certificate that the petitioner is the owner of 1 kata 12 letters, which corresponds to 3 letters of land covered by Dag number 348 old, 716 new of KP Patta number 163 old and 1 Katha 9 lessons covered by Dag number 346 old, 719 new of KP Patta number 165 old, 272 new. Full stop. On the basis of the same, the petitioner had also taken the permission from the Guwahati Municipal Corporation and raised constructions. Full stop. However, in the year 2001, while the petitioner had taken up the, however, in the Jamabandi, in the record of rights, the land of the petitioner has been shown as 1 Katha, 6 lessons, instead of 1 Katha, 12 lessons, for which the petitioner had filed an application for necessary correction of the record of rights, which have been registered and numbered as KRC-M/144/2014. The said application, however, have not been disposed of in spite of the petitioner approaching the respondent authorities time and again, for which the instant with petition. Under such circumstances, the petitioner has approached this court under Article 226 of the Constitution, seeking appropriate directions. This court have also heard the learned counsel for appearing on behalf of the respondent number 2, 3, and 4. Who submitted that appropriate directions may be issued to the respondent number. Who is deciding? 4. Be directed to the respondent number 4 to decide the said application filed by the petitioner in a time-bound manner. Taking into account the above, the instant petition therefore stands disposed of with a direction to the respondent number 2 to it is pending before whom? Respondent number 4. You have filed it before the deputy. Direction to the respondent number 2 to dispose of the said application of the petitioner registered as KRC M/144/2014 within a period of 3 months from the date a certified copy of the instant order is served upon the respondent number 2. This court further makes it clear that the said disposal be either made by the deputy commissioner himself or through his delegatee, that is the respondent number 3. So with the above directions, the instant petition stands disposed. Yes. Bye.
Subdivision officer.
Yes, what is your instruction, madam?
No instructions for
Directing the
Verify and pay.
Yes.
I will. Verify and pay. Verify and pay. 6 months.
31.
Yes, what is this? Payment of what? Contractual bills.
No, I don't.
What is this?
Hello. Yes, there.
Directing and commanding the respondents to follow all the formalities in the construction of the said project and also to prepare all the MR and MBs and bills through the project consultant and pass. Who are you?
We are the member of the sub-provider. Nothing common about it.
Then
Here was the committee was formed to implement the project. EI was formed.
Ah.
EI 2008. And the project consultant, Devasidika was engaged as project consultant. He was prepared, he prepared all the concept papers.
now who is the person who is executing the work? Who is the person who is executing the work?
in PIC, for project implementation committee, which is chaired by the Commissioner of Marketing.
Then why do you want the MIB bill?
MB,
Why these are required, the MR and MB and the bills through the project consultant? Who are you?
we are the members of the sub-provider.
So what business you have? You may be concerned, is it going from your pocket? No.
From the government, okay, but
Understood? It is from the government pocket,
government,
not yours. Does it affect how you are only concerned as regards the construction?
yes, we are interested in the construction. We are
Only that the construction should be in a proper manner.
Yes, my friend.
Then how are you concerned with whether the MR and MBs and bills are made to the project consultant or not?
What is duty? He engaged
And
the
that is a
project
duty, they will do it. If they don't do it, they know what to do.
consultant.
Who are you?
He is our member. Project consultant is our permanent member,
Who?
project consultant.
So,
But they are, without him, they are passing the bill. Right?
so,
Engineer of the PW.
so,
They can make any bill. Right?
So?
If it is prepared to our consultant, they cannot take.
so your consultant is the main, the torchbearer, or if he passes, it is okay. But if it is passed through the executive engineer PWD, it is not okay.
No,
Where is the allegation by you against those executive engineer that he is doing something wrong?
but whatever is prepared by our product consultant, it will be checked, verified by the engineer.
So, who are you? Is the project consultant a party out here? A writ petitioner?
No, he is not a party. He is a-
I don't understand anything. First of all, you are concerned with the construction.
Yes,
Fantastic. So you are concerned that the construction should be made in a proper manner.
yes,
Yes, that is your relief if you are asking. Fantastic. Very well. But here you are concerned that the MBs, MRs and the bills should only pass through the project consultant. Why?
he has prepared all the drawings, which is everything
So what?
by our project consultant.
So what? How are you concerned? The money is to be paid by somebody else to somebody, then how are you concerned? Has the project been completed?
No, no. Up to 6 feet, madam. It was
Huh?
prepared by our project consultant.
What? Auditorium. Auditorium 75% has been done. All have been done. Now what is the present report? Who is the PWD? Oh, PWD doesn't appear. None appears on behalf of the PWD on call for which the instant writ petition could not be taken up for disposal. List the matter on (2011-2023), on which day the PWD is not a major party.
These are concerned effort.
No, PWD, line to Kusab. The people who passed the bill, you have not made a party. Thank goodness.
Registered by them and passed by the concerned effort.
Whatever may be, MB is done by whom?
Now doing by the PW.
Not now. Always the MB is done by the PWD, if it is a government work. MB and MR is always done by the PWD.
Earlier it was tried out for up to the 6th bill.
Yeah.
Up to the 6th bill.
Now thereafter the PWD is doing.
The year.
And why haven't you made the PWD a party? At the request of the Learning Council for the petitioner matter, is then adjourned for 6 weeks. 34, I hope and expect the matter doesn't come again before this court. Next time, no more chance. Yes, none appears for the petitioner on call, yes. Yes, what is your case? APDCL. Where is the electrical accident report? From the above stated facts leading, it appears the victim received the petrol stock while he was working on an electric service connection cable of his neighbor without informing any technical. So reason goes to you. Your fault.
Police report at case.
No, forget about the police report. We are going by the electrical accident inquiry. The report is against you. Unless you set aside the report, there is no way out. And you can only set aside in a civil court. There is no way out. What to do? Dismiss? Withdraw?
About 1 week time I'm taking.
Or dismiss? Giving you the liberty to approach the civil court. Because this court can't impose upon the APDCL any amount because of the fact that APDCL 4 lakh amount which is to be paid is only in respect to if the fault is theirs. That is there. But here the report, electrical accident report is against you.
The electric PDCL inquired the matter.
I'm not concerned with APDCL. Here is a case with the electrical accident report, which is very much against you. So we can't help you. From the facts, circumstances leading to the accident, it appears that there occurred contravention of so and so on the part of the victim. So, can't help you. Unless you challenge. Lahore. I'm giving you liberty to challenge this in the civil court. Because till that report remains, no court can give you. I hope you are aware. Are you aware or not? Huh? Yeah. Let us have it after puja, na? Yes. Is the matter after the puja vacations at the request of the Learned Council for the petition?
36.
Yes, would be filed within 10 days. Given undertaking that the affidavit would be filed within 10 days. in terms with the order dated so and so. This court taking into account the above, the respondents were granted additionally 11 days. However, affidavit which was to be filed by the revenue has not been filed. This court therefore directs the revenue and disaster management by giving an additional opportunity by filing it on by 10/10/2023. Imposes a cost of so and so. No affidavit filed. Huh?
Instruction I had issued.
No affidavit.
Don't be practiced. Day after that.
What?
The instruction I had received.
We have earlier imposed a cost of 7,500. We increase it by another 15,000, make it 22,500. $7,500 is done. You have to deposit. Now, by producing the instruction in this manner, you cannot bypass this 7,500. Yes. Now, there is a direction for you to file an affidavit. By giving that instruction, you cannot bypass that also. So under such circumstances, if you file, earlier if I have imposed a cost of 7,500 and if I don't again impose, it would look bad. People will lose trust. So we impose another 15,000 now. The 7,500 plus another 15,000, which makes it 22,500. You pay, direct the commissioner and secretary to pay from his own pocket. Isn't it? If you had filed it by today also, I would have said something, but you have not. So this court other gives you another time. Earlier I have said file another time. Filing for the final additional opportunity. Now a further additional opportunity subject to deposit of an additional 15,000 beyond this 7,000.
Paucity of time I should not try.
Paucity of time, that is of 25/9. We are today.
Yes.
Then-
The instruction has come late. That is why
Am I asking you to pay the money from your pocket?
I
No. The payment will be made by the commissioner and secretary from his pocket. I will direct the state to pay and realize from his salary from the commissioner and secretary. Matter over. That is how it is to be done. Then only things will move. One has to be strict, no? Now, what is the amount? What is the case?
Your Worship, this is related to compensation, Your Worship.
Under
Under notification dated 2015 or 2014,
then compensation for what?
for died in accident in public places. That was related to-
Both.
Not
Both.
Elect-
So pay that amount. 4 lakhs.
Yes.
No, that okay. That is another thing. That you have paid, it is okay. But here he has to pay. You pay. We'll consider it as you have not filed the affidavit. Lahok. The instant petition has been filed by the petitioner, being agreed at the inaction on the part of the respondent authorities in not paying the compensation to the petitioner in terms with the notification dated 15/11/2014. You need not pay this to 7,500 here. You pay him apart from that 2 lakh. Make it 2,07,500. I'm not going to look.
But that there is a notification, it is defined for this purpose.
Understood. As you have not filed it, we will say that you have nothing to say. That is what I'm going to say. In spite of this direction, you have not filed it. And because of you, I may say that also, because of your inaction on the part of the respondents for good reasons or bad reasons, the state is losing this money. That is also empty. So this amount has to be paid and deducted from the salary of the area if found default. This is a better option. You are referring to that notification wherein it says what is a public place, where it is not accessible.
Yes.
That is it.
Yes, not frequented by.
Okay. Show me that notification. Notification I can, not the instruction. Only the notification. Carry it out. No instruction. Very good. The word public place will mean any street, alley, park, public building, any place of business or assembly open to or frequented by the public or any other place which is open to public. Now, Mr. Goswami, why you have paid him the money? The 4 lakhs? You wouldn't have paid if it was outside. If the payment is always made if it is outside, it's your fault. And when you have made the payment, meaning thereby it has happened outside his private area.
Yes.
So meaning thereby this has to be accessible, maybe wrongly or whatever it may be, it has been assessed by him, which is a public place.
No, Lordship, the accident regarding this case, Lordship, during
Causing from the facts above mentioned leading the accident, it appears that a victim who was not authorized to perform electrical repairing job tried to restore the electric connection. On request of some local resident of the village, the victim tried to restore the connection from another LT feeder coming from other series and thereby got electrocuted as disconnected LT feeder was somehow discharged. From the above facts and so on the part, why did you make the payment? In spite of there being a direction not to pay, that it is a fault of the victim? Because this has a very strong repercussions. In the earlier matter, this court never directs anything, but if you pay in such type of way, but the fault is absolutely that of another of the victim, then the safety of the regular should be complied with by the owner of the supply lines. It is suggested that time to time thorough checking of electors should be carried out at regular interval for ensuring public safety. Any place of business or assembly open to or frequented by the public or any other place open to or which public health exists. Now this LT line which he used, was it open to public access?
For that, your worship, I would like to do your worship, section as page 18, your worship. That is the FIR lodged by the present petitioner, the wife of the victim, your worship. The petitioner was a lineman, your worship, who was engaged in contractual basis, your worship. And on that particular day, your worship, that was the holiday, Eid festival was there. And due to storm, your worship, several lines were damaged, your worship. And the petitioner was, the husband of the petitioner was called, your worship, to repair those lines, your worship.
May I go in the tree, call my husband over the telephone and being a temporary employee, my husband went to that place. Direction was given to repair the damaged wires for the instruction of the Who is accused number 2 and 3? JE.
We have the officers, office bearers of the electric department also, that particular area.
On being informed from the control room that the electricity has been disconnected, my husband started. to
If there's fees, your worship, they have very different.
control room.
Otherwise, if the petitioner, your worship, the content of the petitioner wants to get placed on the board. But,
It appears that the potential employee of the every is. How much it is, if it is, I think, that time flexibility. It is for the of this new things, but that is, accident was. That is not accessible for. That.
No, that may not be accessible to others, but we are accessible to him.
so, this is like-
Accessible to him. Accessible. But more than also, I get the instruction, given the bodies of this, on the whole process. And it's the matter after Puja, I will bring the instruction whether, on what basis, or whether there is any, the report from the electrical inspector.
It's already there.
Yes,
It's already there. Now, recently, Supreme Court passed a judgment. But Mr. Counsel, how do you bring him within the ambit of a public place?
the worship, for that your worship, my humble submission is that your worship, though the place is not public place for general public. But when I went to the spot your worship with authority under direction, that is accessible to me. And during the.
No.
work, your worship,
Accessible to you is as an officer or as a lineman. But is it accessible to all other people?
The cause of action, your worship arises from that particular. point.
Understood, absolutely. But no, the cause of action here is not the question of death. The cause of action here is whether other people are accessible to that place.
For other people, there is no.
So,
access, your
so
worship.
if
But
it is
for the
not,
petitioner,
no, if it is not, then can it be said to be a public place?
your worship, clearly, that is not public place for.
Then if
others.
it is not a public place, then how can you may get for other aspects any amount, but can you get it? Here you are asking this 2 lakhs. Ex gratia to NOK came to air in public places or in public areas. You are on that, number 3.
Yes, your worship.
Yes, then. So how do you get this thing?
Also, otherwise, I would like to rely on some judgments, your worship, and I was waiting for their.
No, forget about that. You get the 7,500, that you will get it. But what judgment you are relying?
Your worship, there are some judgments today, and not that judgments, your worship. Otherwise, I was waiting for their affidavit, your worship, so that I can rely on those judgments, whether that judgment cover.
No. Their affidavit is simple to the notification.
Let them take their instruction, whatever they are seeing.
There is no instruction order. I am not going to give them any further time. I am asking you. Show me on what basis you say that you are entitled to, if the definition of public, the notification has made it clear what is a public place.
I only request you.
The judgments of the Supreme Court or even this High Court would have no relevance if it is not in relevance to the notification, because that notification entitles you. And that notification has been amended out here to say about the notification of 15 But how are you bringing this notification? Is it applicable for whom? This is a modification of a notification of 2014. Understood? But this is not a modification to this.
No.
Then,
It is clarifying what is the public.
no, it is only in respect to impartial modification of clause C of so and so. Is pleased to decide that the next of year killed in human shall be entitled as per norms. The word public place will mean as so and so. This is only for that notification. These are nothing for you, this notification. How are you bringing this notification? No. Are you saying this will be the definition of public place for everything? Are you saying that? Can you say that? When this notification is impartial notification of a notification of 2007? This is a notification which came prior to this. Then how do you bring in this notification? You can't bring this notification out there unless you have. And this notification is only in respect to that. Okay, I'm coming in 5 minutes.
Cannot be treated as not public place, because we are representing the public, the causes of the public. The same thing, Your Worship, not about that particular electric post is not accessible to all. But when the person authorized and with the authority accepts that post, he is representing public. We take that particular interpretation.
Let me give you a better example. That area is a public place. This is not. If you die here, you won't get the benefit under 1511. There you may get. The same thing. Outside that LT line, that may be a public place, but inside where only APDCL authorities or any lineman can have access out there is not a public place.
But with all due respect, Your Worship,
Hmm?
with all due respect, Your Worship, that particular person was not died on that particular line, Your Worship. When he got the electrocution, Your Worship, he later on, when he went to the hospital, he was rushed to the hospital, then he died, Your Worship. But the cause of action is. Your Worship, I would like to rely on some reference, Your Worship. For that, Your Worship, including on.
If I take your example, anybody who gets a shock at his home and then he's taken and have burned an injury of 70% and is taken in the to the hospital, then government hospital, then he dies, it will be a public place. Then
Otherwise, Your Worship, the interpretation is not clear in the notification, Your Worship, and that's the reason why this law was pleased to give direction to them to give their instructions, let them give their instruction, Your Worship, about the public place, whether that particular place comes within the ambit of this notification of 2014.
I'm saying it won't. It won't. Let us assume that this is useless. Now show me that it is a public place.
Also for the public, Your Worship, the person died.
What?
He went there, Your Worship, if a person was under the impression that he would be that particular work because his life was reviewing, he could avoid that particular work, Your Worship. And these are beneficial scheme, Your Worship. The petitioner is seeking the beneficial scheme.
You have already got that. 4 lakhs.
Yes, sir, yes. That area is not the public place, so it is not authorized for anyone else except the authorized person.
He was under the authority.
Yes,
Therefore,
he got the.
if you were under the authority and to enter out there means therefore that it is not a public place. It is within the confines of the rights to be exercised by the APDCL authority employees.
Your Worship, for that, Your Worship,
For what?
to bring the judgments, Your Worship,
What judgments?
whether that particular work comes within the scope of public use or.
Work,
I have some judgments on what.
That area is the very much prohibited area also. No one can enter, no one can enter except the authorized person.
That stand your worship, but when we went there with the authority, your worship, that's the only right.
That's why you got the
And
compensation
in
from
the, in their
every
application, they have passed the speaker that we went there unauthorized. Now they are saying that we went there.
No, as per the office memorandum of the APDC.
just for example, you come here and happen something, then this is unauthorized. Then same thing.
Seventeen, there was again, what is the, if I fail, then definitely we have to invest. Look at this. Not that.
This court, by an order dated 25/9/2023, had granted an additional opportunity to the Revenue and Disaster Management to file an additional affidavit by 10/10/2023. However, the said additional affidavit has not been filed. This court further imposed the cost of rupees 7,500, which have also not been paid. Today, when the matter has been taken up, Mr. A. Bhattacharjee, the learned counsel appearing on behalf of the Revenue and Disaster Management Department, has placed a notification dated 15/10/2014, wherein the term word public place has been defined. A perusal of the said notification reveals that the said notification is in respect to a notification dated 24/4/2007. Further to that, the said notification dated 15/10/2014 was issued even prior to the issuance of the notification dated 15/11/2014, on the basis of which the petitioner has sought the ex gratia payment. Under such circumstances, the said notification dated 15/10/2014 would have no relevance. Be that as it may, the learned counsel appearing on behalf of the petitioner, be that as it may, this court have put a query upon the learned counsel appearing on behalf of the petitioner as to whether the petitioner, who admittedly got, whether the victim, who admittedly got electrocuted while handling the LT wire, LT line, which is exclusively within the parameters of the APDCL authority, would come within the ambit of public place. The learned counsel for the petitioner submitted that he requires some accommodation in the matter. List the matter again. On 17/10/2023, at the top of the list for further consideration. This court further observes that the respondent, Revenue and Disaster Management Department, shall ensure payment of the amount of payment of the cost of rupees 7,500 to the registry of this court on or before the next date without fail, failing which further appropriate directions would be passed against the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department.
37 to 39.
What is the matter about?
But, in the order passed by the revenue board, I have challenged.
Revenue Board order. What is that? Records have come.
Records regarding the revenue board has come, and records regarding Malad County 23 to 23.
What are you challenging?
Your my invitation order was cancelled.
Hmm.
Which partial I think. In the year 2004, I have purchased two plots of land. From one November and one from here the one from the Tinmoy. And both of them were purchased from the predecessor of Kiran Chandra Bhattacharjee in the year 1991. Their name was also mutated. After purchase by me, my name was also mutated. I got the possession, I constructed the boundary work, now I am in possession. In 2012, the private respondent came and saying that he has purchased the land from the regalia of Nagendra Bhattacharjee. So his name may be incorporated in the mutation name. By doing so, they approach before the circle officer. Circle officer, after going through the record, say no, it cannot be. Then they went for appeal, before the additional deputy commissioner. Additional deputy commissioner, my name has been struck off and their name has been incorporated.
Your notice?
Notice with respect to me, I have received, but so far other partners is concerned about the entire plot of land, not only my name has been struck
I'm not
off.
concerned with others. Others are not before this court. I'm only concerned about you.
No, next item number, next item, there are other two items. Other two items. So, I against that, I filed revenue, appeal before the revenue court. Revenue court, while deciding the same, entered into the title, saying that the respondent number one is the better title than me. But without cancelling, they have not challenged my sale deed also. My endorsed sale deed was also not under challenge, not any point of.
Is a
time.
civil suit pending?
No, no civil suit.
Oh, Ventus. So they have a sale deed in respect to the said land?
They are claiming that they have a sale deed in respect of their sale land. I am also claiming,
No, you're claiming, both of you are claiming before the revenue authorities. Why haven't you filed a suit?
my lord, I am in possession. My name was mutated. While my name has been struck off, then I approached before the revenue authority because they have approached.
Are you not aware that there is a sale deed?
That is why I am not aware that when they have approached before the circle of.
I'm not concerned. I'm asking you,
When
are you not aware that there is a sale deed in respect to the same land where you are claiming your right?
My lord, may I appeal one second? My name was mutated.
Understood, Mr.
No,
Ghosh.
I was
Does
in
it take
possession.
so much of time for understanding? I've understood.
Still
I'm asking you a simple question. You have purchased a plot of land A. They say that they have purchased the plot A from the legal heirs of your predecessor in the predecessor's interest.
They are saying that they are partners larger for.
Understood? From the predecessor of their predecessor.
From whom I have also got.
Yes, no problem. Their sale deed is of which year?
72.
And your sale deed is of?
My vendor
You-
said
Vendor sale deed is of?
1991,
So that is a subsequent sale deed.
subsequent sale.
So that is why you have not challenged. What do you say about 48 of the Transfer of Property Act?
Still I am in possession.
Why should this court at all entertain? Why you are not filing a suit?
Still I am in possession.
So what? You are in possession, very good. Remain in possession, file a suit. You can't file a suit because your right is a subsequent right. In respect to a plot of land which have been already sold to him.
My lord, they
These are purely question of facts which
question of fact.
which the civil court should have decided.
My lord, from 4 legal years, and I have purchased from 5 legal years.
Understood. You have purchased for 5, 7, that is immaterial. The same land has already been conveyed in the year 1972 to them. So why should this court at all entertain a writ? It is only a question of payment of the revenue.
Only for a question
You
of-
want to pay the revenue to the government. He wants to pay the revenue to the government. Title is not based on mutation.
But the bill report entered into the fact. That is,
Understood. So that I can very well say that the entering on the yard shall not prejudice you if you move to the civil court. Yes, Mr. Goswami. Matter ends.
Madam, so far as my sale deed is concerned, madam, page 40 or also to find because particularly the offensivity there was very bad. That we moved that by-
No.
And
That-
so far-
Those things I can't decide.
Yes.
Here is the case that the sale deed was, the mutation which was granted in his favor was cancelled by the ADC, taking into account that you have a previous title. And thereupon he went to the Board of Revenue, that Board of Revenue has sustained that order. Now the question is, he is only aggrieved that these orders could affect, that the Board of Revenue has entered into the question of title.
Madam, it has got-
He is only aggrieved by that.
I don't know, madam, my idea is he wants to take a handle from this law so that madam he can cover up these limitations.
No.
Because he has challenged that.
Don't worry. This court will pass that order, making it clear to him. There's no worry. I know what he is trying to do. But that would not change the question of limitation. That is why I asked him, when did you come to know about their sale deed? Maybe they may not know till then. But when the matter was before the ADC, they knew about it. Then, but keeping the limitation open. If they want to approach the competent court, they can. But the question of the revenue court deciding on the question of prime, but what the revenue court will decide in a case of mutation as to title and possession. Now, who is in possession? You say you are in possession, he says he is in possession. So this court cannot decide. The only thing which that has the revenue come to a finding that you are in possession.
Their order was without any notice to us. You will also be kindly mark that. But our order, the three courts.
No, where your mutation done earlier.
No, their order was done earlier, but that was without notice to us. We can.
No, understood, but whether their order was passed when your land was mutated. No,
No.
that is the reason why it must have happened, because when you purchased in 1972, you did not care.
Yes.
And you did not mutate yourself.
Exactly.
And as such, he got his land mutated.
Yes.
And when his predecessor got his land mutated, and therefore, thereafter he purchased it. And on the basis of the mutation which was given in the name of the predecessor, he's got the permission and accordingly purchased it. He got his land mutated. And therefore, after,
2012,
yes,
they have
but, so this is how it has happened. So that I've understood. There is no quarrel with that. Only thing is, what is there out here is he wants that the revenue court could not have decided on the question of title.
That is only pending, but
Yes, page 50.
Page,
Page 50, after hearing the council both sides, including competent.
Page 50.
50.
50. Yes, upon hearing the both sides, the government and then going to the details of legal procedure, we are inclined of the view at this stage, the respondents have a better title as they purchase the land prior to the demand. The above view is also based upon the fact that the appellant had not pleaded in the appeals or provided any deed of conveyance in favor of the vendors, which is a prior dated to the so and so. No, this is not a question of title.
Yes, my lord, this is limited jurisdiction, my lord.
They have gone on the basis, primarily on the basis that he has his title before that.
But that title, my lord, if entered into the marriage, my lord, their title has been derived from 4 legal years.
I'm not concerned.
And my
No.
title has been derived from 5 legal years.
That is a civil suit.
But yes.
That is purely within the civil
Whether
suit.
I got the title from one of the sharer or not, that is to be decided by the civil court. Not by your lord. So while they are.
No, he says about that, yes, he has a,
Better title.
no, not a better title on the basis of 48. That on the basis of the previous title, you will, in respect to the same land, then obviously the second title will not be good. That is on the basis of which he has applied, nothing to say that anything about this thing.
My lord,
Finished.
my only submission is that the title part, regarding title part, and nothing about say with respect to other.
No, I will say that the observation which has been made out there shall not prejudice the petitioner if the petitioner wishes to move the civil court.
Yes.
That's all.
Because I am in position, I am contracted house.
Whatever may be, I'm not on that. I'm only on simple thing. Level. All three are same.
In one case, it was purchased from, Subhash Chandra Saha. It was, vendor.
Is it the same order? One order or separate? Common order, then it's okay.
Appeal is changed. Three different.
These are three different amounts. The instant petition has been filed by the petitioners. Taking into account the similarity of facts and the issues being parametric, the three writ petitions are taken up for disposal by this common order. By this common judgment.
When it is within.
Very good.
2012, they approached.
No, it's okay, no problem. I remember one case, there is a case where a person, there is a wrong notion in some of the courts where you may ask for right title in interest or for declaration of a sale deed to be bare. That is, period is 3 years from the date of the knowledge if you are alleging fraud. But what happens when you are also seeking as regards the possession? Possession will be, there is no possession, there is no period of limitation. There is one judgment out there where it says, when all these three things are there, then the larger period of the possession, the larger of the limitation would apply. Yes.
Question of title is come. Then of title. If question of title.
No, in my opinion, there is no, if you are the owner of the land, there is no limitation for right title interest and asking for possession for recovery, because your recovery is always there. You always have a right over the recovery. But if it is only for a period of declaration, simpliciter, then it is 3 years. But if it is with the consequential relief of the recovery, then there is no possession. You may have it 12 years, but it's a different thing. But there is no limitation because the other side has to prove. If you are the owner of the land at the end of the day, it is found out. Other side has to therefore prove that the possession is adverse. Then the limitation goes to him. Yeah. The instant writ petition, the 3 writ petitions have been filed by the petitioner, by the petitioners, challenging the common judgment and order dated 9/9/2021, passed in Revenue Appeal number 73 RAK/2017, Revenue Appeal 74 RAK/2017, and Revenue Appeal 75 RAK/2017. Full stop. All 3 of you have purchased from this Basanta Pushpa. Or you have filed the appeal?
Yeah.
Mr. Goswami, you filed the appeal?
No,
No, before the revenue board.
they filed it before the petitioner.
Okay. Who purchased from Bokhanda Pushpa?
Bokanda Pushpa purchased it from Ananda, Kiran, Viren, Noren, from Ananda. Bokanda Pushpa is the respondent here. They purchased the Basanti Wala purchased the because of from Nagendra Narayan and Jyotirmoy Chudhary. Subhash Chandra Saha purchased from Nagendra Narayan and Jyotirmoy Chudhary.
From a perusal of the materials on record, it reveals that the writ petitioner in WPC number 6404/2021 claims that he purchased a plot of land measuring 1 katha 5 lechas from Kiran Bhattacharjee, from Kiran Bhattacharjee, Arun Bhattacharjee, Jharna Bhattacharjee, and Noren Bhattacharjee by the registered deed of sale bearing deed number 2913/1991 dated 18/5/1991. The writ petitioner in WPC number 6406/2021 had purchased a plot of land measuring 3 kathas from one Sri Dharneshwar Boro by the registered deed of sale bearing deed number 11192/2005 dated 29/2005. And the writ petitioner in WPC number 5932/2021 purchased a plot of land measuring 1 katha 12 lechas from one Nagendra Narayan Mitra by a sale deed number 9282/2004 dated 22/9/2004.
In fact,
What is that?
my lord, in 5932, 5932, he purchased 2 plots of land.
That is what I'm going to say. I'm about to say that. That is what I'm referring to. Bokhantiwala Devi has purchased 1 katha by registered deed to sale and thereafter another plot of land. Let me complete. I'm saying that. I'm not saying 5932. I'm saying only. Don't worry. This will be correct. Had purchased a plot of land measuring 1 katha 12 lechas from one Sri Nogendra Narayan Mitra by the deed of sale, registered deed of sale number 9282/2004, dated 22/9/2004, and thereafter purchased another plot of land measuring 1 katha 10 lechas from one Jyotirmoy Chaudhary by a sale deed number, registered sale deed number 4228/2005, dated 27/4/2005. The writ petitioner thereafter, pursuant to the purchase got their names mutated, and the revenue records were corrected in their name, and the names revenue records were corrected, and the names appeared in the record of rights. It further reveals from the record that the respondent number 1 is the respondent number 1 in all the petitions. You are appearing for respondent number 1. The respondent number 1 herein in all the petitions claiming right over a plot of land measuring 3 bighas, 2 kathas, 11 lechas. Which he has purchased from Kiran Chandra Bachchaji, Biren Chandra Bachchaji, and Naren Chandra Bachchaji, and Arun Chandra Bachchaji in the year 1972. Arun
I had purchased it from Kiran,
and
and Noran.
Naren,
Yes, yes.
and Naren and Arun Tukusari, and Naren Chandra Bachchaji, and minor he.
Arun was minor at that time. So he didn't figure it.
No, his land must have been sold through his next guardian. No,
So,
I have purchased from all.
okay. And Naren Chandra Bachchaji in the year 1972 filed an application on 27/11/2012 before the circle officer Azra for cancellation of the mutation order of the petitioners. The same petition which was filed by the respondent number 1 herein, which was registered and Miss case number 68/2012/30, was dismissed by the circle officer by an order dated 18/1/2014. Thereupon, the respondent number 1 preferred a revenue appeal before the Deputy Commissioner Kamrup Metro, challenging the order dated 18/1/2014 passed by the circle officer Azara in Miss case number 68/2012/13. The said revenue appeal was registered and numbered as RA number 23/2015/16. RA number 23/2015/16. Why? You prefer before AGC.
Because earlier circle officer rejected, then next, when another circle officer came, he allowed.
That is not recorded here in the order.
The order not recorded, and you see page 39. Then we prefer it.
No. Then the matter was remanded. What? Mr. Ghosh, kindly take you, sir. Let me pass the order. And if there is anything out there, go before the division bench. Enough of disturbance. Don't disturb. No. It's registered as RA number 23/2015-16. The said revenue appeal was disposed of by the Additional Deputy Commissioner Kamrup Metro by an order dated 8/6/2015, directing the Circle Officer Azara for rehearing of the case. Or in other words, the matter was remanded back to the Circle Officer to define afresh. When the matter was remanded back to the Circle Officer Azara for rehearing, the Circle Officer re-registered the said miscase being as miscase number 70/2014-15 and took up for hearing on 7/9/2015. The Circle Officer passed an order on 7/9/2015 cancelling the mutation of the petitioner's hearing by the common order and mutated the name of the respondent number 1. Being agreed, the petitioner's hearing preferred separate appeals before the Deputy Commissioner Kamrup Metro, which were registered and numbered as RA (M) 13/2016-17, RA (M) 14/2016-17, and RA (M) 15/2016-17. The said 3 appeals were disposed of by an order dated 3/10/2017, whereby all the appeals filed by the petitioners were dismissed on the ground that the respondent number 1 had purchased the said plot of land prior to the petitioners. Being agreed against the order dated 3/10/2017, 3 revenue appeals were filed by the petitioners herein, which were registered and numbered as Revenue Appeal number 73 RAK/2017, Revenue Appeal 74 RAK/2017, and Revenue Appeal number 75 RAK/2017. Were filed before the Learned Assam Board of Revenue, which was registered and numbered as so and so. The Assam Board of Revenue, by the common judgment and order dated 9/9/2021, dismissed all the 3 appeals, holding inter alia that as the holding inter alia that as the respondent number one herein had purchased the plot of land prior to the appellants, the respondent number one had a better title over the appellants. It was also mentioned that the said view is based upon the fact that appellants have not pleaded in their appeals or provided in the present appeals any deed of conveyance in favor of their vendors which were prior dated to the deed of conveyance of the respondent number one. Being agreed, the three petitions were filed before this court. The record reveals that only notice has been issued by this court, and the records of the revenue appeals have been called for. I've heard the learned counsels for the parties and perused the materials on record, including the records which have been records in respect to the three revenue appeals. The learned counsel appearing on behalf of the petitioner, Mr. S.K. Ghosh, submitted that the petitioner herein that the predecessor in interest of the petitioners herein had purchased the said lands which have been conveyed to the petitioners from the legal heirs of, from all the five legal heirs of whom? Five legal heirs of one Ananda Bhattacharjee. And as such, the petitioners herein had a better title over the land than the respondent number one, in as much as the respondent number one had purchased the said land from the three legal heirs of late Ananda Bhattacharjee. He further submitted that the revenue board ought not to have gone into the question of title as to who had a better title over the land in question, as it is exclusively within the domain of the civil courts. The learned counsel further submitted that the said observation by the revenue court would affect the rights of the petitioner if the petitioner has to approach the civil court. On the other hand, Mr. B.D. Goswami, the learned counsel appearing on behalf of the respondent number one, submitted. Yes, what did you see? What did you say?
My submissions were basically on the prior sale. 48.
And what about the 3, 5?
He was a minor. Fourth one, Orul was a minor at the time. So they,
Better, I don't record.
my submission. That is on record. And I also say, but I don't know what the record says. The vendors, they are vendors. They said that was not integrated. I am not sure when I haven't seen the record.
And did you produce the sale leads of your vendors? Why did the Board of Revenue say that they were not produced? Oh, they said that not any prior. Mr. B.D. Goswami, the learned counsel appearing on behalf of the respondent number 1, on the other hand, submitted that the respondent number 1 had purchased a plot of land measuring 3 bighas, 2 kathas, 11 lechas,
That is the entire area of the town.
which is the entire area of the Dhat, from Kiran Chandra Bhattacharya, Biren Chandra Bhattacharya, Naren Chandra Bhattacharya. He submitted that Arun Chandra Bhattacharya was a minor at that point of time, and he, even after attaining majority, did not challenge the sale made by his 3 brothers. He submitted that as the title of the respondent number 1, which flows on the basis of the deed of sale bearing deed number. What is it? Where's your deed?
Deed number 7756.
Where is the deed?
Page 45, madam. He, madam, he responded to purchase land measuring 3 bighas, 2 kathas, 11 lechas to register sale name 7756.
Where? Page?
That is the page 45.
Purchase registered sale deed number 7756 dated 27/10/1972. Which was much prior to the land, prior to the deeds of sale executed in favor of the predecessor in interest of the petitioners. The respondent number 1 had a better title by virtue of by virtue of section 48 of the Transfer of Property Act. Ah, 48 of the Transfer of Property Act 1882. The learned counsel further submitted that the learned Assam Board of Revenue, as well as the other authorities, have decided in favor of the respondent number 1 on the basis of section 48 of the Transfer of Property Act 1882. Taking into account the that the respondent number 1 had purchased the deed of sale, purchased the plot of land measuring 3 bighas, 2 kathas, 11 lechas in the year 1972, much prior to the predecessor in interest of the petitioners. And as such, as the same had been done by operation of, on the basis of a statute no interference is required to be made to the order, to the judgment passed by the Assam Board of Revenue, learned Assam Board of Revenue. Impugned judgment passed by the Assam Board of Revenue. The learned counsel further, the learned counsel for the respondent number 1 further submits that the petitioner herein, the petitioners herein, by filing the instant writ petition, have sought for a writ of certiorari for setting aside the impugned judgment and order passed by a tribunal, passed by the learned Assam Board of Revenue. Under such circumstances, this court, in exercise of the powers under Article 2 to 6 of the Constitution, is not exercising the powers as an appellate court. Rather, this court is exercising the jurisdiction, this court, appellate court, but rather the exercise of the jurisdiction of this court is limited to interference when the order passed by the authority is without jurisdiction or there is palpable error causing manifest injustice. In that regard, the learned counsel has referred to the recent judgment of the Supreme Court in the case of Central Council for Research in Ayurvedic Science and another versus Bikartan Das and others, reported in 2023, SCC Online SC 996, and more particularly to paragraph number 50, 51, and 52 of the said judgment, wherein the parameters, wherein the Supreme Court had observed that there are two cardinal principles to be followed by the High Court in exercise of the jurisdiction under Article 2 to 6 of the Constitution for issuance of a writ of certiorari. This court, upon hearing the learned counsels for the parties, is of the opinion that 2 points for determination arises for consideration. Number 1, whether the petitioner, whether this court under Article 2 to 6 of the Constitution can exercise, can determine as to who has a better right over the land in question in view of the respective submissions made by the learned counsel for the parties. Number 2, whether the observations so made by the learned Board of Revenue in the impugned judgment calls for any interference in exercise of the jurisdiction under Article 2 to 6 of the Constitution. Next. Mr. S.K. Ghosh, the learned counsel for the petitioner, let this court first take up for consideration the first point of determination. From the facts narrated herein above, it would show that the petitioners herein claim right over the land on the basis of registered deeds of sale executed by the predecessor in interest who purchased the said lands from the legal representatives of late Ananda Kumar Bhattacharjee. The respondent number one also claims rights on the basis of the deed of sale in the year 1972, whereby the legal representatives of late Ananda Kumar Bhattacharjee and conveyed the land at measuring 3 bighas, 2 kathas, 11 lectures to the in favor of the respondent number one. Though it is the submission of Mr. S.K. Ghosh, the learned counsel for the petitioner, that the predecessor in interest of the petitioners have purchased the land from 5 of the legal representatives of late Ananda Kumar Bhattacharjee. But the respondent number one have only purchased from 3 of the legal representatives. The petitioners have rights over the land have rights over the portion of the land which was not sold by the 2 legal representatives of late Ananda Kumar Bhattacharjee. Though the same aspect is a question which would require a consideration, but the same consideration cannot be made either by the revenue courts or by this court under Article 2 to 6 of the Constitution. Such decisions such claims of the petitioners have to be made before the competent civil courts. Be that as it may, from the materials on record, it is clear that the entire Dag number 14 of Patta number 37, which contained 3 bighas, 2 kathas, 11 lectures of land, was sold to the respondent number one, and by the deed of sale dated 7756, dated 27/10/1972, which is prior in point of time to the deeds which were executed in favor of the predecessor in interest of the petitioners. Under such circumstances, this court finds no grounds, finds that the revenue authorities were within their jurisdiction to cancel the mutation, holding in view of the provisions of Section 48 of the Transfer of Property Act 1882. The next question, which point for determination, which arises, is as to whether this court should exercise a writ in the nature of certiorari in the present facts. The Supreme Court, this court at this stage finds it relevant to reproduce paragraph 50, 51, and 52 of the judgment in the case of Central Council for Research in Ayurvedic Science and another Supra Pustak, as here in below. From a perusal of the said judgment, it reveals that the Supreme Court had observed that there are two cardinal principles for the purpose of exercise of jurisdiction under Article 2 to 6 of the Constitution for issuance of a writ in the nature of certiorari. The first principle is that the court, High Court, does not sit in appeal over the orders passed by the inferior tribunals. It has been observed that the interference can be made by the High Court when the order so passed by the inferior tribunal is without jurisdiction or palpably erroneous, but cannot substitute its own views for those of the inferior tribunal. The Supreme Court further goes on to observe that a writ of certiorari can be issued if an error of law is apparent on the face of the record. Error of the face of the record, and a writ in the nature of certiorari, being a high prerogative writ, cannot be issued on a mere asking. The Supreme Court further observed that the second cardinal principle is that in a given case, even if some action or order challenged in a writ petition is found to be illegal and invalid, the High Court, while exercising its extraordinary jurisdiction thereunder, can refuse to upset it with a view to doing substantial justice between the parties. It was observed that it was perfectly open for the writ court exercising this flexible power to pass such orders as public interest dictates and equity projects. The legal formulations cannot be enforced divorced from the realities of the fact situation of the case. Further to that, it was observed that while administering law, it is to be tempered with equity, and if the equitable situation demands, after setting right the legal formulation, not to take it to the logical end, the High Court would be failing in its duty if it does not notice equitable considerations and mold the final order in exercise of its extraordinary jurisdiction. The Supreme Court further goes on to observe that any other approach made by the High Court would render the High Court a normal court of appeal, which it is not. In the instant case, now applying in the backdrop of the above propositions, if this court applies the ratio to the facts of the instant case, it would be seen that the learned Assam Board of Revenue, while passing the judgment, learned Assam Board of Revenue was competent as per law to pass the said judgment. This court further does not find any palpable error in the exercise of the jurisdiction by the learned Assam Board of Revenue in the impugned judgment and order. Under such circumstances, the question of interference under Article 2 to 6 of the Constitution is not warranted in the instant case. In that view of the matter, the instant writ petition, all the three writ petitions, being devoid of any merit, stands dismissed. Before concluding, this court, however, finds it relevant to observe that the observations made by the learned Assam Board of Revenue in the impugned judgment, as well as the discussions made herein, shall not prejudice the petitioner if the petitioners approach the competent court of jurisdiction as regards their title. With the above, the instant holder, the records, the registry shall forthwith return the records.
In the year 1990, there was no return.
এইটো অকমান লিখি লিখিব হা 6404 এটা যে কৈছে এখানে এইটো যত লিখিব নহয় purchase from the predecessor of the petitioners have purchased the petitioners as well as the predecessor will লিখিব the line can be used like this now the petitioners or the predecessors who have purchased the
40 to 41.
orders order from you did you give it 40 and 41 yes oh this one you did not file an affidavit
No, in fact, no, there is no record. So, in the, I got it, all the bills were sent from this individual. Right?
Huh?
The-
so this is more good it must have been sent from your individual email so where is it you could have filed the affidavit
No, no, in fact, I do not need action with Mr. Abdul Dutta, the organization secretary.
why
He's almost bad with it because lots of things have happened. In fact, certain the files and all from the FTA were all seized by the police in connection with some effort caused by the against the LS contact. Because the Honorable Secretary lots of the things that happened thereafter.
Hmm?
In fact, no, even the petitioner has lost an FIR with the Automatic Proceeding. Accordingly, the was removed from the Honorary Secretary post. And in fact, the documents and all, there's lots of disapprobation or
you are appealing for whom
both a Assam Football Association as well as the content. Because the Honorary Secretary at that
no
point,
contempt for football repetition con I kept it alive like the last time
this is item 41.
so
He was the Honorary Secretary at that point of time. Document asked me to provide, to produce the email. But the fact remains, there is.
what is the health condition of this Ankur Dutta?
The last time I met him, it was some months ago. He was accompanied by his son. He's unable to work. It's almost dead. And in fact, I could not contact him. So I tried his phone numbers at this time.
So will Ankur Dutta is not represented.
In fact, I had represented the contact at that point of time.
Now you are not representing.
In fact, since I had already, I thought I'll be there, but there's no connection.
So you make a submission that you are not going to represent and you will issue notice to him.
I can,
I think that is better.
or I can send a notice itself. Because if there is no address, as such, we don't have any residential address.
Whatever may be, this is a personal contempt against that person. Are you representing him or not? I'm asking you a specific question. If you are, then you have to bear a brunt. You can't say that he is bedridden. I'm not concerned with all this.
That is, I can send a notice to him. I'll have to send a notice to him.
That is your lookout.
That is-
What you want to do, that is your lookout.
that is what I have since I have kindly I will literally represent, but there is no.
Yes, Mr. Gupta, what benefit are you going to do now? Get out of this contempt? What benefit are you going to get? He is no longer there. Nothing is there. This is an old case of 2014-13. That you were there, that document reached later on for which you could not. What happens? 9 years have gone by unnecessarily drawing up this litigation. You have the time and energy for doing all these things, but the sport doesn't have the time. We'll have it in 2025. Not 25, 35. Yes, unnecessary litigations. What is that to do with this type of litigations now? Tell me, what happened? Understood, that happened then. Understood, you could not. But now what is there to do now on the basis of an interim order? Nothing remains now. Understood, but when it is, if this action would have been taken then and there, it would have been better. Now, what is this court is going to do with a bedridden person? Unnecessarily dragging him those people out there. No, is it going to do any favor to you? You do one thing. I dismiss your contempt. You file an appeal. Then in the appeal, let the division bench consider you have any case on. I don't think. What affidavit? Matter over. Enough is enough. We impose a cost upon you now, the court. No, enough. There's no further. This is a whole matter. 2014, an interim order not being followed. Yes, it is there. They say that it has been followed, given, and you say that it has not been given. And how the email has been given and not. He doesn't have it. He says. Here I say order is it? Repetition from the rule issued. The repetition is admitted for hearing. List the matter in the usual course. Contempt case of Tibo. List the matter along with the WPC number 2653/2014 for hearing. 42. This will happen after in 2025. No affidavit in opposition has been received for the excise department till today.
Lordship, as per our instructions, there has been no violation of license condition.
Violation of?
License condition in order to take any action against the private respondent.
Then
That's-
what is the order? Is the contempt or a reach?
No. I can't read it. Respondent number, the private respondent has the answer of nothing. But just to my, I am highlighting the license company. I have filed representation for finance. My limited for the employee department. And they have for time, 4 times of it for filing affidavit. The matter we limited to the finance for the employee and by hearing both the parties.
Yes.
Lordship, as per our instructions, it is clear that there has been no violation of license conditions as alleged in this resolution.
Where is the instruction? What is the violation? Cannot be located within a radius of 500 meters from the educational institution and religious institution. That order, what has happened to that order of 2013? Does it remain any further? Everywhere you are still having it?
For the paragraph, if I have
Mr. No, understood.
Look up 2 kilometers from the license.
Now, what happened to that order of 2013? Tell me, what happened to that order of 2013? Has it been complied with thereafter? Now, do you see wine shops? Then, unnecessarily don't keep these matters pending.
No, this is not that. The license of the study, the place.
Mr. Doctor, save your energy for some better cases, not this type of cases.
Yes, finally further inquiry, that's not limited there.
No, because this will open a Pandora's box. Do you know the reason why the 2013 judgment was passed?
So my case.
No.
Based on
2013.
I know that. You know the reason why 2013? The superintendent of tax excise then did not like the Midtown Kitchen, who had a bar license. And as such, maybe because he was not given some proper treatment, for which he came out and he cancelled the license. When a matter came up before the court, why? They had no other reason. The superintendent of excise says, look here, his shop is very near to the church. This resulted in passing of an order whereby it was said that don't have it anywhere,
Overnight, they made a product.
everywhere. And you want a similar thing that the moment I ask for an inquiry, it will again start another Pandora's box.
No, my-
I understand whatever player, whatever way. This type of litigation, your matter earlier, Mr. A.K. Gupta's matter, unnecessary litigation. You have better time to do. You want the instructions, see the instructions. Yes. And here it says the distance from the IMFL shop to the nearest educational shop should be 100 meters as laid down in 289(2). Yours is 500 meters.
What about my ground, first ground?
What is your first ground?
That I am not running kilometers far away from the license location.
From the?
From the license location. What is that location, license, as per license, location is somewhere, but running in another. We are in fifteen.
What if that point has been addressed in that instance, that I don't know, subsequently by a government order, it was changed, the location was changed.
And then here it's a, but subsequently the said shop was shifted to the present premises by the government order dated 7/8/2000 and not violating the license conditions. So,
I don't know. That's why.
so may we will close it. The instant writ petition has been filed by the petitioner being aggrieved by the non-consideration of the complaint dated 1/12/2016 filed by the petitioner against the illegal running of the IMFL shop of the respondent number 5. So it transpires from the said complaint that there are two grounds on which the said complaint was filed. First, that the wine shop was located within a radius of 500 meters from the educational institution and religious institution, which contravenes the order dated 28/6/2013 in WPC number 2856/2012. And further, the shop is located 2 kilometers away from the license location. Mr. Aibot Thakur, appearing on behalf of the Excise Department, submits that as per the Rule 289(2) of the Assam Excise Rules 2016, IMFL off shop can be situated at a distance of 100 meters from the nearest educational, religious, or any medical institution in the urban area. He further submits that though the respondent number shop was originally granted at Amalapati, Dibrugarh in the year 1995, but subsequently the said shop was shifted to the present premises by government order number EX.194/90/PT/203 dated 7/8/2000, and as such is not violating the license condition as stated in the petition by the petitioner. Taking into account the above stat, which have been made by the respondent authority, which clearly shows that the complaint which have been filed has been duly addressed to, this court finds no reason to entertain the writ petition any further, for which the writ petition stands dismissed. Withdraw, close. Don't keep on filing. Okay, close with cost of 10,000 upon the lawyer. No. Yes, और ये last time के लिए Mr. P.P. Dottor submits that in view of the said submission made by Mr. Aibot Thakur, the learned standing counsel for the Excise Department, he the grievance of the petitioner have been duly met, for which he would not like to further press the instant writ petition. Accordingly, the writ petition stands closed.
43.
Yes, contempt. Yes, complied. Huh? Okay. Now, why the matter has come today? Because it's a contempt. No, 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 no. Service upon the respondent number 5 has been received back as unserved. 1, 4, 3, 5, 2. You have to take fresh steps upon 2 and 5.
Modi, Dr. Modi, I don't think 2020 was busy by that. During that time, I filed comment 21. Just after filing, he was transferred from there. Thereafter, some 2-3 diseases was filed.
It's okay. Let him take steps.
He has to complete ballot group.
That he knows. If he doesn't know, then it is his lookout. The office note shows that the service upon the respondent number 2 and 5 is not complete. Taking into account the petitioner is directed to take fresh steps upon the respondent number 2 and 5 by registered post as well as usual within 7 days. List the matter after completion of service upon the respondent number 2 and 5.
Before.
Taking into account that the service is complete, list the matter for admission after the purifications.
55.
Yes, Mr. Rai.
Here we are challenging the order dated 10/11 because
That is okay. Notice has been issued to the respondent number 14 to 20 by the registered post on 18/7.
this is complete.
How do you say so?
The office note dated 26/6/23 shows it has been during some upon 11 to 13.
Okay, the service being complete, list the matter for admission after the purifications.
Here, number 2,
Huh? Who has died? Who is 2A?
there is that.
You know? You know now?
Yes, and but he is representing our daughter. So he may be likely to furnish the names of the legal assistant.
Her daughter.
2B is the daughter of.
So 2B is already there. So what is the required for other thing? You were earlier representing 2A. So Mr. M. Kalita. Mr. M. Kalita, representing the respondent number 2A and 2B, submits that the respondent number 2A had expired. So taking into account that respondent number 2B is the daughter of the respondent number 2A. So this court finds no reason for further substitution. List the matter for admission.
46.
List accordingly. Yes, Mr. Withdraw.
Yes, I have already filed.
Mr. R. no, appearing on behalf of the learned counsel, appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant petition, taking into account that in respect to the subject matter of the instant petition, a suit has already been filed. Taking into account the above, the instant repetition stands closed on withdrawal. The interim order passed on 23/12/2021 stands vacated.
47 to 51.
I think we are. Yes, what are these? Early hearing. Okay, Gita, when do you want it? What is the matter pertains to?
Compensation of that and then the. I know the high voltage transmission lines was constructed over the petitioner's. And when the work has already been completed without reversing the.
Service is complete. Okay. Take, I only one. Okay. The instant interlocutory application has been filed for early hearing of the writ petition. Taking into account the materials, this court finds it pertinent, finds the reasons justifiable for taking up the matter for early hearing. List the matter. Has it been rule issued? No. What is the status? No rule issued. Notice. Taking into account the above, this the matter for admission immediately after the Puja vacations. I extend this motion. On. Don't take adjournments. On 15th of November.
52.
Yes, Mr. Chaudhary. It's a late. Yes.
Despite order of this honorable court, my just still not permitting.
Oh, that matter.
Yes.
There's an order passed by this court also,
Yes,
I
yes.
suppose. What they are doing it.
Lord, they're not there. In fact, now they have passed an order, my lord, and we come to page 52.
Ah.
Now they are interpreting the order in their own way.
Thank you for
Thank you
sharing
for
the
sharing
honorable
from
court. I would
this
like to
order,
inform you that termination notice will be put on hold until further direction is provided. I would like to repeat the
Earlier interim order, which must be the final order. Access to any other facility we go can will be prohibited according to cost and including purchase which the grant received from the state with Tabaka. Relocate this system and equipment wherever required after modifying the problem. Charge for safeguarding this property, that may enter the area only for the purpose of safeguarding this property with permission from the agency. The initial restriction was interfered with, then subsequently also while they passed an order, where lordship passed that stay order. The lordship's order is that my lord is number 46.
Upon by the impugnement whereby clause 9 was invoked.
This code upon duly perusing the return by the account with prior to the execution. There is no mention in the complication. It is laying down the foundation for invoking clause 9 of the should will be next day, so take directed, no action be taken. Present the complication within 12 days.
What has happened to the writ petition?
Repetition is pending matter.
These,
Change the matter.
in fact, these are the writ petitions which needs urgent disposal. Na?
Yes. After the vacation,
I can't, na. I don't have that. Otherwise, I would have finished the. In my court, the early hearing unnecessary. All matters are. In fact, what happens out here, maximum of the matters are useless. That's why you will be shocked, means the manner in which the writ petitions are filed, useless writ petitions. It's just filed for the sake of. And honestly, I was just telling Mr. Gupta out there, this person is not well. There was a direct interim order passed once to the effect that allow him to participate in that particular training camp in 2014. And because the documents were not given, it as a note was given. Now, can that writ petition survive any further? No. And the contempt on that is going on till now. And this person, the contempt is nowhere connected here, and he is now bedridden.
Some classification of the cases can be done. I think this type of cases can be disposed of.
But
Some special bench should be possible.
no, in fact, in all fairness, the council for the parties, council should also be more here thinking, because unnecessary one matter here takes more time. The other two matters,
Where time is required to be given, there is no time.
we'll issue notice.
Where is- okay.
Issue notice, making it returnable by November 15th, 2023. Steps be taken by the petitioner upon the respondent number 1 and 2 by registered as well as usual within 3 days, by Monday.
Monday.
Because we want to take steps by the state. The petitioner is also given the liberty to take steps by way of dusty routed through the registry of this court and file an affidavit of service on or before. Then things move. This is my normal time.